1/3 quarter of 2016, Solidarity Outlook Members versus South African Broadcasting Corporation.
As it pleases the court, I appear for the applicants in this matter, together with my learned friend, Mr. Brainders.
The court pleases. Yes, my lord, together with Mr. Madlanga, I appear for the respondent.
Your senior preparing for judgment next week, I believe he's sitting in the High Court next week.
Indeed, my lord.
Okay.
He's held up.
All right, I'm sure no one will be disadvantaged by his absence. All right, as you probably gathered, I'm sorry we're starting so late, but the roll this morning proved a bigger obstacle than I'd hoped, so it's something of a late start. Let me just situate you in terms of, I got the answering affidavit, and I know that the replying affidavit was filed during the course of this morning. I must tell you now that I haven't had a proper look at the replying affidavit, but I'm sure in the course of the proceedings you will allude to that. Perhaps you want to just take a seat for the moment, Mr. Butlander. I've read the gist of it as far as it concerns me. At the moment, I would just like to raise with you the issues that I feel, no doubt you will deal with them, but just in case you are maybe completely at odds with me as to what you think the important issues are. There are a number of them which I just jotted down, and please do not accept them as being mentioned in order of importance. That's not the intention. It was really in going through the papers that these issues came up. The one issue, and I'm sure all of them are obvious to you, but I just think it might help you in your submissions. The one issue which has arisen is the supposed reason for the dismissal of the applicants, and whether it was because of any objections they might have voiced in relation to the policy directive suppressing coverage of certain events, or whether it was for other related or unrelated reasons. It seems to have become an issue in the case. Then the sort of vaguely related question, or not vaguely, but a related question is whether the policy directive, let's just call it that, the editorial directive, applied to them as well, to all of them. Then another issue is, insofar as they were entitled to a disciplinary hearing before their dismissal on the 18th of June, did the applicants, were they provided with an opportunity to state a case, and if so, did that satisfy the requirements of the hearing they were entitled to? So there I'm obviously just concerned about that aspect of claims of unlawfulness that have been made. Of course, one of the big questions which has been raised by the respondent, by the SABC, is whether this court indeed has jurisdiction to intervene in these circumstances if the requirements of the hearing they were entitled to, whatever that might have been, were not met. There's maybe a debate about that. More generally, to the extent that the applicants base their claim on allegations of unlawful dismissal, does the court have jurisdiction to pronounce on that? Then another issue which I trust you will address, it seems to be, and maybe I don't fully understand what the respondent is getting at, but there's an issue raised about the relevance of the fact that disciplinary processes, I won't go so far as to call them proceedings, appear to have been commenced in one respect earlier on than last week, prior to what we call the so-called Schedule 8 notices, which were issued to the applicants on the 8th of July. And in this regard, as I understand the respondent's argument, the SABC wants to suggest that there's a clear break between the proceedings initially initiated in June and those which were initiated by the notices issued on the 8th of July. Then some of the, or another issue which concerns an aspect of the case which concerns me, were the dismissals affected at a time when the SABC knew that the applicants were seeking urgent relief to uplift their suspension or to prevent further disciplinary steps being taken pending the outcome of the Constitutional Court action? Then, to the extent that the SABC was warned that an urgent application would be filed to interdict disciplinary proceedings, what effect does that have, if any, on the possible claim of constructive contempt or possibly costs? There's also a related question there of the identity of the decision makers who took that decision to dismiss the applicants, who haven't been identified as far as I recall in the papers, but that may come up as an issue towards the end. Then, and this is again what I was saying earlier, the points I raised are not in any particular order of importance, but the respondents, the SABC, are arguing that although this is an application for interim relief pending the outcome of the Constitutional Court proceedings, which I think are the only ones now that are, so to speak, pending, that it's not true interim relief that the applicants are seeking, but final relief. That's the true nature of the relief they're seeking, and that means that a different legal test would apply when determining whether they have a right to the protection or not. Then, just and there's really a point of detail in relation to the narrative of events set out in paragraphs 28 to 38 of the founding affidavit. The respondent didn't really deal with them. They gave some reasons why not, but they just dealt with them in the broadest terms. But it is a matter which I hope the respondents will explain, is that I see that the deponent to the answering affidavit, Mr. Tebele, he was in fact involved in some of the incidents mentioned in those paragraphs, and he didn't use the opportunity to even comment on that directly when one would have thought he might have. So just have a question mark about that. All right, I've dealt with the question of a potential constructive contempt claim and the identity of persons who might be affected by that. The respondent, SABC, has made out an argument why that wouldn't be competent relief in these proceedings. And then coming back to one of the earlier points, although it's related to them, is what is the extent, or what was the extent of the obligation to conduct a disciplinary procedure as contemplated in the applicant's contracts of employment. And obviously that's one aspect of unlawfulness. The other aspect is whether there are other constitutional rights they may be relying on to assert their claim that their dismissal was unlawful because it was such a fundamental constitutional violation of their rights, if I understand that argument. All right. Enough from me. Those are just thoughts off the top of my head, if you like, from reading the papers, and issues which I'm sure you plan to address anyway. So let me hand over to the parties. Mr. Budlander. Anyone got heads? I haven't seen any heads of argument. Be nice to get some.
Could I begin there, my lord? Could I hand to your lordship first a bundle of authorities we've prepared and a set of heads of argument we've prepared, and which will form the basis of the argument today.
All right. Are the heads the thinner document on the top?
They are indeed, my lord,
Okay.
particularly in light of the time constraints.
It's all right. You can hand me yours when you... Have you got some, Mr. Scusa? Okay, thanks. And you've exchanged heads, no doubt.
We have
Okay.
indeed, my lord.
All right, good.
My lord, this case is about what we say and submit to your lordship are the quite extraordinary This case is about what we say are the quite extraordinary and indeed cynical attempts by the SABC to prevent its journalists from expressing any disagreement or dissent internally or externally in relation to the now infamous protest policy. We don't make that submission about cynicism and extraordinary conduct lightly. We say it is borne out by the papers, and we're going to take your lordship to why that is so on the facts. What we propose to do in the course of this address, my lord, is to begin with the essential facts, because in truth there are no material disputes of fact that should prevent your lordship from deciding this matter. But given that the facts are scattered all over the papers, it is necessary to take your lordship through what the essential facts are. We will then turn to deal with the dismissals, because it is with the dismissals that we must begin, because if we can't come home on the dismissals, then it's not clear that anything remains in relation to the suspensions and the pending disciplinary proceedings. So we will focus on the dismissals, and we will demonstrate to your lordship that the dismissals breached both the employment contracts and the Bill of Rights, and that on either basis your lordship is entitled to order reinstatement. Thirdly, we will then deal with the suspensions and the remaining pending disciplinary proceedings. We will submit to your lordship that both the suspensions and the remaining disciplinary proceedings are inherently unlawful and also in breach of the Bill of Rights, and that your lordship can therefore grant the interdictory relief which is sought. We are going to submit to your lordship that in light of the answer that has now been filed and the developments that have taken place, your lordship can do so on a final basis and not on an interim basis. But I will come to that. Lastly, my lord, we will deal with the question of costs, both in relation to the scale of the costs to be paid by the SABC and the question of who is to pay those costs. And it's in that context, my lord, that we will deal with the question of constructive contempt of court, or to put it somewhat lower, inappropriate and impermissible conduct in the face of pending applications to court. But I will leave that until then, because, as I will explain to your lordship, there's been a judgment from the Constitutional Court just yesterday which bears on that and makes the position somewhat more complex than it might have been. And so we're going to leave that until the question of costs, because we don't really need it in order to establish the unlawfulness.
I think we did touch on that yesterday, and I think I suggested that it may be something, if we have to get there, which might be separated from the urgent proceedings anyway.
Yes. We're going to ask your Lordship, just to give your Lordship the end point, we're going to ask your Lordship to make an order that the SABC at least disclose who the employees were who were involved, because there's no need for that to be delayed. But the question of whether those employees are personally liable for the costs will have to stand down or stand over for another day, because they will have a right to be heard. So we'll get there, but we will not be asking your Lordship today to seek that an individual employee is liable for the costs. But we will ask your Lordship to set in train the process to enable us to do so. So could I begin then, my Lord, with the essential facts? And I'm now at page 2, paragraph 3 of the heads of argument. And let me say, my Lord, that the facts that I'm going to deal with are all essentially common cause or undisputed. Because as your Lordship has correctly pointed out, there are a series of relevant facts which have not been dealt with in any way except the broadest and most general denial. And there is no explanation for that failure apart from what is said to be a lack of time. And we will say and submit to your Lordship that it is plain that on the Plascon-Evans approach, the detailed version of the applicants, confirmed by their confirmatory affidavits, must prevail over the broad general denials of a deponent, Mr. Tebele, who ought to have had personal knowledge of some of those facts, but who appears not to have personal knowledge of many of the other facts, but in respect of all of them, just issues a sweeping and bare denial covering 10 or 20 paragraphs at a time. We will say that on trite principles of Plascon-Evans, that means that the applicant's version must be accepted. And it would be surprising with respect if our learned friends were to disagree with that fairly elementary proposition. So can we begin then, my Lord, at paragraph 3, where we say that on 26 May 2016, the SABC announced its protest policy. We call it the protest policy, but nothing turns on whether it's called the protest policy, the policy directive, the editorial directive.
We all know what we're talking
We know what we're talking about, precisely. It's the statement that was made on 26 May 2016, which pertained to the extent to which the SABC would or would not cover violent protests against the state. And the papers make clear, my Lord, that that policy was met with widespread condemnation from civil society and from political parties across the spectrum, including the African National Congress. Its legality was almost immediately challenged by Media Monitoring Africa, SOS, and FXI in the Complaints and Compliance Committee of ICASA. That complaint was launched a matter of days after the policy was announced. And your Lordship will know from reading the papers that the Complaints and Compliance Committee of ICASA is the body that is statutorily set up to deal with complaints that a broadcasting licensee has not complied with its obligations. Now, despite this extraordinary public debate and extraordinary public condemnation, and despite the pending proceedings in the CCC, the SABC was intent on preventing any external or internal debate about the protest policy. Now, my Lord, that is not merely a submission. That is a factual allegation which is made on the papers and which is not denied except in the baldest terms. So your Lordship need not go there necessarily. We've given your Lordship the reference, but at page 10, paragraph 30, in the founding affidavit, which was of course filed almost a week ago.
So just before I forget, because I know it's going to be quite a long argument, after the proceedings, can I ask the applicants to make sure that I've got a properly numbered bundle and properly bound bundle of pleadings?
Yes, certainly, my Lord.
Okay, thanks.
So at page 10, paragraph 30, the allegation is made. The SABC was intent on preventing any internal or external debate about the protest policy. Even internal criticism of the protest policy by very senior journalists was therefore met with an immediate disciplinary response. That allegation is not meaningfully dealt with anywhere in the answering papers, and indeed the tenor of the answering papers, which says that the applicants are being disciplined because they protested or because they disagreed, confirms the correctness of that allegation. But the allegation is not made in only general terms, my Lord. Your Lordship will see from the passages that follow that it is made in very specific terms, and examples are given. And so we know that 5 days after the policy was announced on 31 May, the second and fourth applicants, that is Mr. Kricher and Ms. Pillay, were summoned by the COO, Mr. Motswaneng, to a meeting to discuss a number of issues over which he was unhappy. These included the fact that on 2 previous days, SABC radio shows had included comments from independent analysts which criticized the process policy. So it wasn't that the talk show hosts were criticizing them, it was independent persons who were put on the radio and were criticizing the protest policy. And what is undisputed in the Plascon-Evans sense before this court is the following: that during the meeting it was made clear that the SABC wanted complete compliance with the protest policy and did not want any criticism of the protest policy aired, even if it was criticism by independent analysts. That Mr. Motswaneng stated, and this is quoted in the founding papers, and your Lordship will see from the attached constitutional court papers that in that court the notes of the meeting from Mr. Kricher are put up, but in any event there's no denial from anyone, no meaningful denial from anyone, including Mr. Motswaneng, that Mr. Motswaneng said to that meeting, if people do not adhere, get rid of them. We cannot have people who question management. This is the last time we have a meeting of this kind. And that in that same meeting, Mr. Jimmy Matthews, who was then the CEO, said, it is cold outside. If you do not like it, you can go. You've got 2 choices, the door or the window. Now, my Lord, not only are those allegations not denied in the papers, they are in our submission consistent with the series of processes that followed and the current stance of the SABC that even though it is finally conceded that the protest policy is unlawful, it will give no quarter whatsoever to the 8 journalists it has fired for criticizing that policy, including the 2nd to 5th applicants. So that's the meeting of the 31st of May.
Well, it is I'm just going to interrupt you there. It's really maybe a question which the respondents want to no doubt think about is in terms of the public perception and the perception of current staff at the SABC. What are they to make of the retraction of or rather a concession that the policy the ban should be lifted? At the same time, the corporation insists on disciplining those who defied the ban. I don't know I'm just trying to think of the position of an employee who's currently at the SABC, how they might perceive the sincerity of that approach.
Well, my Lord, my learned friend will no doubt make submissions on what he thinks the implications are, but could I make submissions on behalf of my clients? We think the implication is clear. The implication is that the SABC has finally been forced, against all its judgment, or against all its wishes, to accept that the protest policy is invalid, and that is, of course, is only after serial litigation in ICASA, in the High Court, in the Con Court, and countless hundreds of thousands of rands being run up at taxpayers' expense. But they have finally been forced to capitulate. But they are still intent on ensuring that in respect of the protest policy and other policies and other political issues and the newsroom, they will have no disagreement from anyone. And so they say, fine, we accept that the protest policy is unlawful, but you who had the bravery and vigor to criticize it, you are out in the cold. We are not letting you back in. And the implicit message conveyed to every SABC journalist is if you cross the line, as the current applicants did, you will be out in the cold too. And that's our submission on what the implication is, but we'll hear from our learned friends. So that's the meeting of the 31st of May, my Lord. And we then come to the next major event, which is the 20th of June. And on the 20th of June, and I'm now at paragraph 7 of the heads, the Right to Know campaign, which your Lordship will know is a prominent civil society organization, protested against the adoption of the protest policy outside of the SABC offices in Johannesburg, Cape Town, and Durban. And on that morning, a newsroom diary meeting was held to discuss which events would receive coverage that week. My understanding is that that's a meeting that is held commonly to decide which events will receive coverage. And again, the following facts are alleged in the founding papers and are not disputed in any meaningful way, despite the fact that they involve Mr. Tebele, the deponent. Firstly, that Mr. Tebele announced that the 3 protest marches were to be scrapped as stories and afforded no coverage at all by the SABC. Secondly, that the second and third applicants, that is Mr. Kricher and Ms. Venter, along with the third colleague who is not a party to these proceedings but is a party to the Constitutional Court proceedings, Ms. Gubule, placed on record their disagreement with this decision not to cover the right to no protest. Could I just pause there? As appears from the papers, it was merely a placing on record of disagreement. There is no suggestion on these papers of a refusal to obey an instruction, because as the papers reveal, despite the disagreement being placed on record, the right to no protest were not covered. So it's a mere disagreement or dissent, expressed vigorously, admittedly, that is placed on record. And 3 days later, all three journalists are promptly suspended and disciplinary proceedings are instituted against them. Could I just take your Lordship for a moment to orientate your Lordship to two documents which appear in the papers and which are helpful. And they're not cited in the head, so if your Lordship would make a note. Firstly, if your Lordship would go to page 191 of the papers, it's Annexure FA9. There your Lordship will see the notice of suspension which is issued to Mr. Kricher. The other notices of suspension are in identical terms. But I would just emphasize 2 points. The first is that it has come to management's attention that you have allegedly refused to comply with an instruction pertaining to the provisions of the SABC editorial policy, as well as the directive not to broadcast visuals/audio of the destruction of property during protest actions, and that you distance yourself from that instruction. As I've explained to your Lordship, in fact, the facts reveal it was merely a dissent and a vigorous disagreement, but there's no suggestion of a failure to comply. But that's not the main point. The main point is what follows. The above alleged offence constitutes a refusal or failure to comply with a reasonable and lawful instruction, and same impacting negatively on the day-to-day broadcasting operations. I would ask your Lordship to make a note of that, because when I come back to deal with the suspensions in due course, I'm going to point out to your Lordship that the SABC's stance of defending the suspensions is inexplicable, because it suspends Mr. Kricher and his colleagues on the basis that he refused to comply with a reasonable and lawful instruction. It now accepts the eNCA decision, which says that the instruction was not lawful at all, and which declares it invalid with retrospective effect. And yet it still says that Mr. Kricher and his colleagues committed a wrong in doing so. Then if your Lordship would turn a few pages on to page 194 of the papers, Annexure FA11, your Lordship will see there the notice to attend disciplinary hearings issued to Mr. Kricher, and again it applies equally to the third applicant. And your Lordship will see in the second last paragraph on that page that the charge. The charge is that in your capacity as executive producer, so a very senior employee, you allegedly categorically distanced yourself from the instruction issued by SABC management not to cover the right to know movement marches. That is, campaigning against the SABC decision not to broadcast violent protests. So the charge in relation to the disciplinary proceedings is absolutely emphatic. It is, as Mr. Kricher admits, that he disagreed with the decision about right to know, and he placed that on record, and that is what he is charged for. And that is inextricably bound up with the protest policy, because, of course, it was a protest that was not broadcast, and the protest by right to know was against the very protest policy at issue. So again, when we come back in due course to deal with the disciplinary proceedings, not the Schedule 8 proceedings, if I can call them that, but the other disciplinary proceedings, we will raise that for your Lordship.
I seem to recall, and again, Mr. Kosana will correct me, but somewhere in the answering affidavit, I seem to recall that the SABC said that some of the applicants
Yes.
were not actually bound by the policy because they work for
Yes.
other radio stations within the stable of the SABC.
Yes, there's an irony about this, is that the SABC seeks to make a virtue of the fact that 3 of the 4 journalists concerned are radio journalists. And therefore it says, the implicit point is, why do they even care about the protest policy? Because the protest policy affects only visuals, and therefore they shouldn't worry. That seems to be the point that is being made. But of course that stands in stark contrast to the fact that that is what the journalists are being prosecuted for or disciplined for. But let me say, my Lord, we don't seek to make anything of that, because we think that the point taken by the SABC to say that radio journalists shouldn't care about the policy is simply without any merit. And we've addressed that, my clients have addressed that in the replying affidavit. Your Lordship need not go there. I'll just give you a reference because it is a somewhat ancillary point. But in the replying affidavit at pages 334, paragraph 11, the applicants explain why they care about the protest policy. And they say it's true that it doesn't impact directly because they're not showing visuals, but it impacts on the audio they can do because it affects where the cameras will be, what is shown, where the interviews happen. And perhaps more importantly, they emphasize that the protest policy undermined the credibility of the SABC and its journalists as a whole, that it seriously imperiled the credibility of the SABC with its viewers and listeners, and that the 2nd to 5th applicants' internal criticism of the policy was driven by their deep concern for the SABC as a public broadcaster with a constitutional mandate, their deep concern for the interests of the public, and their deep concern for their own personal credibility as journalists employed by and associated with the SABC. So with great respect, it's a point that the SABC seeks to make something of, but it doesn't go anywhere. So there is a further point where the SABC's answering affidavit is inconsistent with the contemporaneous documents. Because your Lordship will see, and it appears from the passage of the answering affidavit we've footnoted there at paragraph 8, that the SABC says the reasons for these disciplinary proceedings, and again I'm talking about the first disciplinaries, not the Schedule 8 notices, were that the second and third applicants had criticized the protest policy via the media. Now, that's what they say in the answering affidavit at paragraph 16. Could I just give your Lordship a page reference, because when the heads were prepared we didn't have that reference. It's page 317. And there they say, I reiterate that the employees were not charged for a refusal to comply with the statement or the so-called editorial decision, but for making comments in the media about their opposition to such policy, which was contrary to their employment contracts. My Lord, that's quite wrong, in respect of at least Mr. Kricher and Ms. Venter. But for present purposes, it doesn't matter, because we're going to submit to your Lordship that even if the SABC's answering affidavit is taken on its face, and even if your Lordship is to accept that the suspensions and disciplinary proceedings were because of criticisms, perceived criticisms that the applicants made in the media of the protest policy, it is still hopelessly unlawful and unconstitutional. So your Lordship doesn't need to become engaged in a debate about whether the reason was about internal criticism or external criticism, because even accepting the SABC's version, it is hopelessly unconstitutional and unlawful, as we will submit to your Lordship in a moment. So we've dealt with the initial suspension and disciplinary proceedings in respect of Mr. Kricher and Ms. Venter, that's the second and third applicants. Now we come to the fourth and fifth applicants. And at paragraph 9, we make the point that on 26 June, so that's 3 days after the suspensions, the fourth and fifth applicants, along with a further colleague, Ms. Ntuli, sent an internal letter to the senior managers at the SABC, recording their concern about what was occurring at the SABC, including the protest policy and the suspensions of Mr. Kricher and his colleagues. That was an internal letter, and the letter was then obtained by the media and published. And again, that is pleaded in the founding affidavit, and again, that is not squarely dealt with. So there's no explanation about how the media got hold of it, and the version of the applicants is that it was leaked, and there's nothing to gainsay that. 3 days later, my Lord...
Can I just ask
Yes.
you, in relation to that,
Yes.
were the fourth, just remind me, were they charged with leaking it later?
They were later charged with making statements to the media, and there was no specificity given. My junior will find the charge sheet in respect of them, and I'll
just come back to
I'll
that.
give your Lordship a reference in a moment. I think it's next to the reply, isn't it? Just find the original charge sheet first. I'll come back to it. My junior will make a note. So what then happens, so we're now in a situation where there are suspensions of Mr. Kricher and Ms. Venter, and there are disciplinary proceedings against Mr. Kricher, Ms. Venter, Ms. Pillay, and Mr. Steenkamp, and there are, as well as 4 other colleagues. And what happens is that on the 9th of July, those 8 SABC journalists, now known almost across the country as the SABC 8, and I'll refer to them as such if your Lordship would permit me. The SABC 8 are awarded the Nat Nakasa Award by the South African National Editors Forum. And as your Lordship will know, the South African National Editors Forum is a body that includes journalists and editors from all over the country, print media, broadcast media, private media, public media, including the SABC. And the Nat Nakasa Award, my Lord, is an award which the papers show is awarded annually to a media practitioner who has shown integrity, commitment, and shown courage in the media. It was awarded to all 8 applicants, my Lord, in relation to the events at the SABC. A number of the applicants then attended the award ceremony, but only one of the present applicants said anything at the award ceremony, and that was Ms. Pillay, who went on stage, and when they received it, she read out the terms of the SABC's mandate. That is its duty to educate the public and be a public broadcaster and adhere to the Constitution. And she said, until this is achieved, #not in our name. That is what she said. One would have thought, my Lord, that the fact that the industry had recognized the bravery and integrity of the SABC 8 would make the SABC think twice and perhaps reconsider. But in fact, it didn't. Instead, what happens is on the morning of Monday, 11 July 2016, notices in terms of Schedule 8 of the LRA are issued against all of the relevant journalists, including the 2nd to 5th applicants. I'll come back to those notices and whether they were lawful in a moment, but for the moment, let's just say that the notices were issued. Could I, before carrying on, give your Lordship an answer to your Lordship's question? Your Lordship will find the original charge sheet against the 4th and 5th applicants at page 371 of the papers. It's annexed to the replying affidavit. And your Lordship will see there that it is alleged that Mr. Steenkamp had distributed the letter to the media. That is what was alleged at that stage. And then later on, your Lordship will find the Schedule 8 notice, which is at page 185, which is where, again, it's expressly alleged that he leaked it to media platforms. But let me say that there is no factual evidence whatsoever to support that. And in fact, there's not even a bare allegation that that is the case. When Mr. Steenkamp says, and when the applicants say it was an internal letter and it was then obtained by the media, there's no denial or an attempt to engage in it. But again, for present purposes, nothing matters, because I'm going to take your Lordship to constitutional court authority, which is directly on point, and which makes clear that even if it had been proved that Mr. Steenkamp and Ms. Pillay had leaked the letter, that would still not be a lawful basis for dismissing them. Because in the case which I'm going to take your Lordship to, the Lotteries Board case, that is precisely what happened, which is that there was an internal grievance letter, it was leaked to the media, and the majority of the Constitutional Court held that that was protected expression and an automatically unfair dismissal, and it couldn't follow. But could I return briefly then to the sequence of events and back to the 11th of July. So the 9th of July is the Nat Nakasa Award. The morning of the 11th July, the Schedule 8 notices come. And the afternoon of the 11th of July, the CCC hands down its decision, declaring that the protest policy was invalid with retrospective effect. Could I take your Lordship to one aspect of that decision? Your Lordship will have seen that the judgment of the CCC appears at pages 26 to 47 of the papers.
I read that. Yeah.
And the passage I wish to refer your Lordship to is at page 46. Your Lordship will see there the third paragraph. It goes 1 and then it goes A and then it goes B. It says, the order by the SABC as articulated in its policy statement is in conflict with its duties as a public broadcaster and was invalid from its inception. And then at the foot of the page is the order by ICASA itself, the ICASA Council. The Council of ICASA directs the South African Broadcasting Corporation to withdraw its resolution as published in its statement of 26 May, and over the page, as a whole retrospectively, as from the date when the resolution, as published in the above quoted statement on 26 May, was taken. So I'll again come back to the implications in due course, but it's absolutely clear that the ICASA decision, which the SABC now accepts, and we've put up the letter in the replying affidavit, the ICASA decision makes clear not only that the protest policy decision was invalid, but that it was invalid ab initio and that the SABC was under a duty to withdraw it retrospectively to the date of it being announced. Now, the ICASA decision comes down on the 11th of July, and the response of the SABC and Mr. Motswaneng is immediate. Within 2 hours of the ICASA decision, Mr. Motswaneng calls a press conference, and he immediately announced that the SABC would not comply with the ruling, as no one is going to tell us what to do. That is his quote, and it's borne out by the various media articles. 4 days later, my lord, the SABC, and that's on the 15th of July, the SABC 8 launched their urgent application in the Constitutional Court, challenging both the protest policy and the disciplinary proceedings against them. And on the same day, the present applicants launched the present application, in which they sought from this court an interim interdict, pending the outcome of various fora, and I'll come back to what those were in a moment and where it stands. So they seek an interim interdict from this court, interdicting the SABC from proceeding with the disciplinary proceedings, pending the outcome of these various proceedings. Could I say, my lord, there is an attempt by the SABC in its answer to make something of the fact that the reference to disciplinary proceedings only applied to the original disciplinary proceedings rather than the Schedule 8 notices. That attempt, my lord, is absolutely futile, with great respect, because when you have regard to the founding papers, it's quite plain that the Schedule 8 notices not only form part of the cause of action, but form the very basis for urgency, because on page 9, paragraphs 20 to 27 of the founding papers, the very basis for this application being urgent is said to be the Schedule 8 notices. And so it's said, if we don't get to court urgently, we're worried the SABC is going to dismiss us pursuant to the Schedule 8 notices, and we need an interim interdict. So the suggestion that disciplinary proceedings meant only the original ones and not the Schedule 8 disciplinary proceedings is, with great respect, entirely inconsistent with the papers. So the Constitutional Court proceedings are launched on Friday, 15 July. These proceedings are launched on Friday, 15 July. And having done so, the applicant's attorneys write to the respondent, and that letter appears at page 244 of the papers. And in that letter, it's made plain that the Constitutional Court proceedings have been launched, the Labour Court proceedings have been launched, and that in the circumstances, the applicants considered that it would be inappropriate at this stage to respond to the charge sheets. Suffice it to say that our clients deny all the additional charges against them. So the suggestion by the SABC that there was no response is not correct. It was a denial of the charges against them and an explanation as to why no further particulars were given, which is that it was inappropriate because this litigation was now underway. And the point was made expressly there that an organ of state, all parties, and particularly in organs of state, are not permitted to conduct themselves in a way that prevents the courts from granting relief, and that an attempt by the SABC to proceed with disciplinary proceedings would be unlawful and would amount to constructive contempt of court. And it concludes, we trust that the SABC will not do so. Now, just let me pause there. It may have been, of course, that the SABC was advised that the legal position was different and that it was entitled to proceed with the Schedule 8 inquiry. But one would have expected that a responsible organ of state at that point would have written back a letter which said, "Dear Mr. Claassen, we disagree with your assessment. We consider that there is nothing stopping us from proceeding. Take whatever steps you deem fit." Because then what could have happened is that this application could have been set down on a couple of hours' notice to seek an interim order, an urgent interim order pending yesterday. So if the SABC was playing open cards, and if it genuinely had a different view as to the way the legal landscape looked, it would have written back a letter, expressed its disagreement, and enabled the applicants to take steps to protect their rights. But it didn't do so. It didn't respond to this letter at all. It filed a notice of intention to oppose, and then on the night of Monday, the 18th of July, it proceeded to dismiss the 2nd to 5th applicants and did so on the basis that the employees were criticizing the editorial decision, their suspension, and the SABC management. So the basis for the dismissal, and again this is the SABC's version, which we've quoted at paragraph 15 of the heads, the basis for the dismissal, and they say it so in express terms, is that the employees were criticizing the editorial decision, that's the protest policy, their suspension, and SABC management. So let there be no doubt, my clients have been dismissed because they criticized the policy, and because they criticized the suspension of some of them, and because they criticized SABC management. That is why they've been dismissed on the SABC's version. And we will submit to your lordship that on the clear authority of the Lotteries Board case, that is patently unconstitutional.
I mean, I can't remember exactly what they said, although you quoted, but my understanding was that the SABC is trying to suggest that it was the public nature of the
Yes.
criticism which was offensive.
I think that's correct. I think, with respect, I think your lordship is correct. They're trying to suggest it's public criticism, but as your lordship will see from the Lotteries Board case, that's precisely what happened in that case. So, and we're now almost finished with the chronology, but 2 days later, so on the 18th of July, the 2nd to 5th applicants are dismissed. I should interject to say that on the 19th of July, 3 of the other SABC 8 are also dismissed. And then on the 20th of July, in the face of those dismissals, the SABC proceeds to capitulate in, just wondering if that date is correct. Was it the 20th of July? If your lordship would just give me a moment. That might be a typo.
The matter was heard on the 21st, was it not, or was it?
Just want to get the.
Was it heard on the 20th?
It was heard on Wednesday, my lord.
It's the 20th.
I've lost track of the days of this week. I apologise. It is the 20th. It's correct. So on the 20th of July, 2 days after dismissing my clients, the SABC belatedly writes to ICASA and indicates that it will abide by the decision of the CCC regarding the protest policy, and that is to be found in the replying affidavit, page 342, paragraph 35. We've given your lordship the reference. And it also consented to an order in the High Court in the Helen Suzman Foundation case, interdicting it from giving effect to the protest policy. Perhaps this is a convenient point just to take your lordship to that order and just emphasize one element of it. And that order, my lord, appears on page 383 of your lordship's papers. And the only point I wish to make, and I don't have an explanation for it in view of the capitulation to ICASA, but that quite peculiarly the SABC has only agreed to an order in terms of Part A. So it's agreed to an order in terms of Part A that pending the final determination of Part B, including any appeal of the review proceedings under Part B, it will abide by that order. So it appears, at least on the face of this order, that Part B of the Helen Suzman Foundation case is still alive, although one doesn't know what the SABC could possibly argue in that case, in view of the fact that on page 387, 3 pages on, it has now agreed that it will accept the order of ICASA. So on the 20th of July, we have this extraordinary about turn. The SABC changes its mind, accepts the order in the Helen Suzman Foundation case, and agrees to abide by the ICASA decision. And yet, despite all of this, the SABC makes no offer at all to the journalists, the SABC 8. Instead, what it does is it comes to court yesterday. It seeks a postponement to file answering papers. When it's given time to file answering papers, it puts up a version which largely takes points about jurisdiction and which contends that there was nothing wrong at all with its decision to fire the 2nd to 5th applicants. We submit again that this is an extraordinary and cynical stance and that it is patently unlawful and inconsistent with the Constitution. Could I proceed to deal with that now and explain to your lordship why that is so in our submission? So we're now dealing, and if I could focus on that, on the dismissals. We're leaving aside for a moment the suspension and the uncompleted disciplinary proceedings, and we're focusing on the dismissals. And just to give your lordship the overview, we make 2 points, and either of them is good enough for us to come home. We say, firstly, that the dismissals were in breach of the employment contracts. And on the authority of this court in the 2 cases that we've cited, Ngobeni and Dayakala, on that basis alone, this court is entitled to intervene and reinstate the employees. And secondly, and in any event, we say that the dismissals were in breach of Section 16(1) of the Constitution, which is a provision of the Bill of Rights, and that we rely on the Lotteries Board case for. And we say that on that basis, too, this court is permitted to reinstate the employees. But could I deal with each?
Can you just elaborate on that? Why did the court admit a direct if you like, application of a constitutional right in that case?
No, I mustn't be misunderstood, my lord. In the Constitutional Court, in the Lotteries Board case, the court wasn't enforcing the constitutional right directly.
See,
It concluded that the dismissal was automatically unfair, because in that case, the case
that's
had
what I
been,
thought.
yes, the case had been brought squarely in reliance on the Labour Relations Act. But this case is different, because in this case we have specifically pleaded and relied on Section 16(1) of the Constitution. But we say that the reasoning of the Constitutional Court in relation to the rights of employees and their right to criticise their employers when they're public institutions, it follows from that inevitably that the Section 16(1) right has been violated. And then this court can exercise its power under Section 157(2). So we don't suggest that the cases are on all fours, but we do suggest that the reasoning makes clear that there is nothing impermissible about an employee criticising a public institution which is his employer, even in the public domain. But I'll come back to that in a moment, if I may. So to deal first with the employment contracts, we've reproduced for your lordship the relevant provisions there. And your lordship will know that clause 20 of the employment contract provides that if the employee breaches the agreement or violates policies or acts inappropriately, acts illegally, the SABC shall be permitted to take the necessary disciplinary actions as allowed and detailed in the relevant labour legislation and SABC disciplinary procedures and code of conduct. Such action may result in the dismissal of the employee and termination of this agreement. And we then take your lordship to the disciplinary procedures. And the disciplinary procedures are emphatic. Firstly, they make clear that they are part of the employment contract. That is clause 1.5, which provides that the disciplinary procedure and code of conduct supplements the personnel regulations and together with the said regulations form part of all employees' contracts of employment. Then, and let me say, my lord, if your lordship would go to page 283, your lordship will see the disciplinary code. There are two provisions I haven't emphasised we haven't emphasised in the heads, which I would wish to draw to your attention. We've referred your lordship to 1.5, but if we go up and deal with the objectives of the disciplinary procedure, your lordship will see 1.3.3. One of the objectives is to avoid hasty or ill-considered judgments or actions by management and to ensure that no employee is disciplined without just cause. We submit that that is perfectly consistent with the interpretation of the contract we are advancing, which is that a formal disciplinary hearing has to be held when someone is to be dismissed. Two further indications that that is the proper construction of the code are clauses 1.6 and 1.8. Because 1.6 says, in special circumstances where serious misconduct appears to be the case, the employee may be suspended pending the holding of a disciplinary hearing after the employee has been advised of the suspension in writing. In other words, the clear implication is even if it's a very serious misconduct, you must still hold a hearing, but you can suspend the employee to protect the SABC. And then the third indication, again on that page, is clause 1.8, which is an exception to the general rule, but which is inapplicable. And 1.8 says, notwithstanding anything contained herein, any employee who allegedly breaches his conditions of employment by participating in unprocedural collective industrial actions such as strikes, boycotts, go-slows, or overtime bans, or who incites other employees to participate in such unprocedural collective industrial action, need not be dealt with in terms of this disciplinary procedure and may be summarily dismissed. In other words, the general rule is you must have a proper hearing, but in respect of this narrow category, you can do summary dismissal. But that is inapplicable to the present case, and it's never been alleged that the applicants have engaged in any form of industrial action. And in fact, what your lordship will know, when we come to, from the replying affidavit, when we come to the march, and the march doesn't amount to any of those, but in any event, the march, the only three applicants who attended that, Ms. Pillay didn't attend it. Mr. Kricher and Ms. Venter were already suspended, and Mr. Steenkamp was on his day off. So there's no suggestion that they didn't work, that they were striking, they were boycotting, they were having a go-slow overtime ban. On the contrary, all of them were not required to report for work that day because two of them were suspended and one of them was on leave. And the only person who was required to report for work was Ms. Pillay, and she reported for work and didn't attend the march. So clause 1.8 is plainly inapplicable, but it makes the point that the general provision under the disciplinary code is you need a formal hearing, and it's only in this narrow circumstance that there is an exception. That is confirmed beyond doubt, my Lord, by clause 4.5 of the disciplinary procedures, which appear at page 286, but which we have quoted for your Lordship. And that says, for misconduct or offences which in the opinion of management warrant a stronger disciplinary measure than a verbal warning, a formal disciplinary hearing must be held. It's absolutely unequivocal. It says if you're going to do something stronger than a verbal warning, a formal disciplinary hearing must be held. So we say, my Lord, that the contract of employment, including the disciplinary procedures, is unequivocal. You cannot dismiss absent a formal disciplinary hearing. And the reliance on Schedule 8 is there, and of course clauses 4.6 and following then explain the procedure to be followed in a disciplinary hearing. It has to be a trial, there's got to be a right to lead and cross-examine witnesses, etc. Now, the SABC in its answer seeks to say, well, that's not good enough, because the first clause that we quoted, clause 20, says that the SABC is permitted to take the necessary disciplinary actions as allowed and detailed in the relevant labour legislation. And the SABC disciplinary procedures. And they said that means we don't have to rely on the disciplinary procedures, we can simply rely on Schedule 8 of the LRA. My Lord, that is a totally, with great respect, stretched reading of the clause. What the clause plainly means is that you have to comply with both. You've got to comply with the labour law and you've got to comply with the SABC disciplinary codes. And where the SABC disciplinary code makes clear that you have to have a formal hearing, that must mean that you can't rely on Clause 8. And that is made clear by all of the provisions which I've referred your Lordship to, including the objects of the disciplinary code. So we know that on the basis of the contract there had to be a formal hearing, and we know that that's not what happened, because a formal hearing was commenced in respect of all four of the employees, but in respect of all four it was not concluded. Instead, the SABC changed ship midstream shortly after the Nat Nakasa Award was awarded, and they proceeded to issue the Schedule 8 notices. We say, my Lord, that violates the contract. The contract prevented that, and there is a plain violation of the contract. And on that basis, the dismissals were unlawful. Now, our learned friends say unlawfulness is not a basis for this court to intervene necessarily. And they appear to rely in that regard on the Steenkamp versus Edcon judgment. We will await their argument on that, but I would submit with great respect that the Steenkamp judgment is of no assistance to them, because that was a case in which the applicant sought to rely on a provision of the LRA to invalidate the dismissal. And the Constitutional Court explained that in the context of relying on the LRA, one cannot do so because of the various procedures and the appropriate remedies and the need on occasion to go off to the CCMA. But in this case, my Lord, we don't rely on the LRA for the unlawfulness at all. We rely, my Lord, on the conditions of employment, the contract of employment. And it is trite that this court has jurisdiction to deal with that issue because of Section 77.3 of the Basic Conditions of Employment Act, which provides that this court has concurrent jurisdiction with the civil courts to hear and determine any matter concerning a contract of employment. And of course, it has the power to order reinstatement in terms of Section 77A of the BCEA. Now, my Lord, this court has done that at least twice. It's done it in the Ngobeni case, which we've referred your Lordship to, and the Dayakala case, which we've also referred your Lordship to. Both of those cases are in your Lordship's bundle. I'm not going to take your Lordships to the judgments. One is by His Lordship Mr. Justice Van Niekerk, the other by Her Ladyship Ms. Justice Passon. But I do just want to summarize the effect of those cases. In both of those cases, my Lord, precisely the same thing happened. The employees were senior employees. They were subjected to disciplinary proceedings, formal disciplinary proceedings. But the employer became frustrated by the pace at which, by the pace at which those proceedings were going. And so in each case, it proceeded to dismiss without completing the disciplinary proceedings. The facts are not on all four, because there they don't seem to have issued Schedule 8 notices, but that's irrelevant for present purposes. What is relevant is that in both cases, this court found that the employees had had their contractual rights breached because of the shift away from the formal disciplinary proceedings and the dismissal without completing that formal disciplinary proceeding. And in both cases, the court said There is no need to rely on the LRA for this. Your contract of employment gives it to you, and in terms of the BCEA, this court is entitled to intervene to order reinstatement, and it did so in both cases. We submit that there is, apart from the absence of the Schedule 8 procedure, which is immaterial given what we are relying on in this contract, there is no basis to distinguish those cases. And so this court plainly has the jurisdiction and power to order reinstatement and to determine that the dismissal was in breach of the contract of employment. And nothing in the Edcom versus Steenkamp case changes that. And to the extent that our learned friends persist in that, I will deal with it in reply. We have given your lordship Edcom versus Steenkamp in the bundle, Steenkamp versus Edcom in the bundle of authorities. So, my lord, that's the first ground. If your lordship is with us on that, that's the end of the point, because your lordship doesn't need to proceed to the second ground. But the second ground is a self-standing basis. And the second ground is that the dismissals were in breach of Section 16(1) of the Constitution. Now, your lordship will know, and I'm now at page 9, paragraph 26 of the heads, your lordship will know that Section 16(1) of the Constitution confers a right to freedom of expression, which includes the right to freedom of the press and other media, freedom to receive and impart information or ideas, freedom of artistic creativity, and so on. Now, the SABC in its papers admits, my lord, and I've taken your lordship to this point already, it admits that the reason for the dismissals is that the employees were criticizing the editorial decision, the protest policy, their suspension, and the SABC management. That, my lord, is protected expression, because all speech is protected expression under 16(1), except where it is excluded under 16(2). So hate speech is excluded under 16(2), and advocacy of war and incitement to cause harm. But none of this falls under 16(2), and they don't appear to suggest so. So this is protected expression. And the question is, can the SABC dismiss the employees for exercising their constitutional right to freedom of expression? And we submit that the answer to that is given by the Lotteries Board case, albeit in the somewhat different cause of action that was relied on there. Because in Lotteries Board, what had happened was that there had been a series of dismissals. And we've given you the Lotteries Board case.
That was a case where they demanded removal of certain people.
Yes, your lordship has it. If your lordship considers the first paragraph, I'll just read it to your lordship, of the minority judgment, it summarizes it. It says, what protection does the LRA afford to employees who demand the dismissal of their CEO with a threat to stop work if the demand is not met, and then associate themselves with a letter about the poor performance of the CEO, which their union leaks to the press, all during a conciliation process in terms of the Act?
Which is not factually on all fours with this case.
No, absolutely. If anything, it's a far more severe form of protest and can I put it this way? The CEO of the Lotteries Board would have a great deal more to be unhappy about than the CEO of the SABC, because this was a direct attempt to remove him from his position and a threat to stop work completely if the demand were not met. And it was all in the context of a conciliation process. And the minority held that that was not automatically unfair, but the majority held that it was automatically unfair. And the majority judgment of His Lordship, Mr. Justice Zondo, and your Lordship could simply make a note for your convenience, appears at page 45 of the bundle of authorities. But the passage on which we rely is paragraphs 187 to 190, which appears some distance in, and that is at page 66. And what His Lordship, Mr. Justice Zondo, says there, and it's a long quote, but if your Lordship would indulge me, I'll just read the most relevant parts. He says, firstly, the union and its members have the right to freedom of expression under Section 16 of the Constitution. So, although the case was not premised on that as a cause of action, the Concourt expressly makes the point that there's that right, and expressly makes the point that this was protected. Secondly, under the LRA, the union has a right to serve the interests of its members and to decide on its own programs, activities relating to how best to serve the interests of its members. And he makes the point that the fact that the Lotteries Board disagreed, or the court might disagree, doesn't make it unlawful. Thirdly, the respondent is a public institution. Fourthly, the public has an interest in how the respondent as a public institution is run. Fifthly, in terms of the Lotteries Act, which establishes the Respondent and regulates it, the Respondent is bound by the values in Section 195 of the Constitution. Those are the values of accountability and transparency which apply to all organs of state. And then he carries on. The Respondent is an organ of state. The union and employees were unhappy with the leadership style and the way of doing things of the CEO of a public institution. One of the issues they raised was linked to the principle in Section 195(1) of the Constitution. That relates to ensuring that the organisation was broadly representative of South African people and taking measures to address the imbalances of the past in the workplace. The public had a right to know whether the CEO as the respondent of, the public had a right to know whether the CEO of the Respondent as a public institution was implementing this important constitutional principle. In all these circumstances, the union was entitled to cause the publication of those parts of its letter of 23 May that got published. It was entitled to seek support from the public for its complaints about the head of a public institution. Indeed, it was right to say that it was entitled to publish its correspondence with the Respondent when it deemed it appropriate to do so, provided that there was nothing in that correspondence which would render the publication thereof unlawful. Now, my Lord, it's hard to imagine a dictum more on point. We here too are dealing with a number of journalists who have a right to freedom of expression under Section 16 of the Constitution. We here too are dealing with a public institution. We here too are dealing with a public institution in respect of which the public has an interest in seeing how it is run. In fact, I would dare to say, my Lord, that the members of the public have a greater interest in how the SABC is run than how the Lotteries Board is run. Because what the SABC does on a daily basis, and the papers make this clear, affects what 21 million South Africans see and hear. Those are not the only viewers of the SABC, but those are the 21 million members of the public who depend on the SABC as their primary source of news and information. And then we are dealing here again with the fact that the SABC is bound by the Constitution. They are bound by Section 195 of the Constitution, but that wasn't really raised. But they are bound by Section 16 of the Constitution. And that was the very focus of what was said about them. So when the Concord tells us that the public have a right to know whether the CEO of the Lotteries Board was implementing Section 195 of the Constitution, it must apply with even greater force here. And it applies with even greater force for two reasons. And that is what we address at paragraph 30 and following. Firstly, my Lord, with no disrespect intended to members of the employees of the Lotteries Board, they are ordinary employees. They are presumably clerks and accountants and cleaners and drivers, and of course they're entitled to constitutional rights. But journalists, my Lord, are in a different position. Journalists are the bearers of ethical and constitutional obligations, which go to the very heart of their daily existence. And we have drawn to your Lordship's attention the ethical duties and obligations which all South African journalists must aspire to, and which are set out in the ICASA Code, the BCCSA Code, and the Press Council Code. My Lord, those are publicly available documents, but we can make them available to your Lordship if it would be of assistance. We have, however, quoted the material aspects. And what the ICASA Code and BCCSA Code provide, and that's on page 11, top of page 11, is that news must be presented in the correct context and in a fair manner, without intentional or negligent departure from the facts, whether by distortion, exaggeration, misrepresentation, material omissions, which is relevant here, or summarization. Then the Press Council Code commits journalists to the same considerations, and the preamble supports that. It says, as journalists, we commit ourselves to the highest standards, to maintain credibility, and to keep the trust of the public. This means always striving for truth, reflecting a multiplicity of voices in our coverage of events, and acting independently. And then Section 2 of the Press Council Code says that journalists shall not allow commercial, political, personal, and other non-professional considerations to influence or slant reporting. And my Lord, it is with great respect self-evident the problem that the protest policy created for the applicants. In their view, and in the view of ICASA, now confirmed by the SABC, they couldn't comply with both. They couldn't comply with their ethical obligations under the codes and with the protest policy. They considered the one anathema to the other. But it's not only a question of ethical obligations, it's a question of constitutional obligations. Because what the Constitutional Court has said, my Lord, again and again, is that the media, which includes journalists, are not merely the bearers of constitutional rights, but they are the bearers of constitutional obligations. And so in Kumalo versus Holomisa, what the court said was, the print, broadcast, and electronic media have a particular role in the protection of freedom of expression in our society. Every citizen has the right to freedom of the press, and the media, and the right to receive information and ideas. The media are key agents in ensuring that these aspects of the rights to freedom of information are respected. In a democratic society, then, the mass media play a role of undeniable importance. They bear an obligation to provide citizens both with information and with a platform for the exchange of ideas, which is crucial to the development of a democratic culture. As primary agents of the dissemination of information and ideas, they are inevitably extremely powerful institutions in a democracy, and they have a constitutional duty to act with vigor, courage, integrity, and responsibility. The manner in which the media carry out their constitutional mandate will have a significant impact on the development of our democratic society. Now, Your Lordship has seen what the journalists say. What they say is that we considered it our duty to act with vigor, courage, integrity, and responsibility, and we couldn't do so when we were complying with a protest policy. That's what they say in their letters. That's what they say in the contemporaneous meeting, which is not denied. That's what they say in the constitutional court papers. They say we can't do both. We can't comply with your protest policy and comply with our constitutional obligation. So, again, with no disrespect to employees who work for any other institution, employees who are journalists have particular duties.
Can I just ask you on that? What difference, if any, does it make whether I work for a private media house or a public broadcaster like SABC?
Your Lordship has put his finger on the very next point I was coming to at paragraph 31, because what we say there is that journalists at the SABC are under a particular duty to advance the public interest, because the SABC is a public broadcaster with a special mandate. And we've quoted for Your Lordship what the Constitutional Court has had to say, that the SABC as a public broadcaster provided for and regulated in terms of the Broadcasting Act has a special function to perform. When the SABC is involved, what is at stake is the right of the public to be informed and educated. So, my Lord, Your Lordship is not asked to decide today whether every employee is entitled to criticize their employer in public and have that protected and not be dismissed for that. Your Lordship is not even asked whether every journalist is required to do that. And one day there will be a case about whether a journalist at ETV or a journalist at Media 24 has these same rights and what difference it makes. But what is absolutely undeniable is that in the present context, where we have employees of a public institution who are journalists, and where that institution is not merely a public institution, but the public broadcaster, it is unquestionable in our submission that the SABC journalists had the right and arguably the duty to draw the attention of the public to these developments, to the problems that the developments were causing for them, and to the damage that it would do to the public's right. And once that is so, my Lord, it simply cannot be constitutionally permissible to dismiss them for exercising that right. Because a constitutional right which results in dismissal is a right which is not properly being exercised or protected. Let me say, my Lord, that there is a suggestion, it appears, in the SABC's answering affidavit, that this is not a good argument because there is a policy of the SABC which says that journalists mustn't talk to the media without permission of the CEO. That seems to be the focus of the attack. We say, my Lord, that is not a sustainable argument, and it is not a sustainable argument for this reason. Whatever that clause means, and whether that clause is enforceable at all, it is not enforceable here against the journalists, because in view of the considerations we've outlined, it is plainly contrary to public policy. And we would commend Your Lordship to an authority, it's not in our heads, so if Your Lordship would make a note, to the case of Mapango, M-A-P-H-A-N-G-O, versus Angus Lifestyle Properties, A-E-N-G-U-S, Angus Lifestyle Properties, 2011, Volume 5 of the South African Law Reports, page 19, a decision of the SCA. My Lord, that case actually went on appeal to the Concourt, and I think it was overturned. But we rely on the summary that they give of the law about public policy and the Constitution, which was not doubted, because it's a very convenient summary. So at paragraph 26 of that judgment, His Lordship Mr. Justice Brunt, speaking for a unanimous court, said the following. Paragraph 26. A. According to well-settled principles of our common law, a term of a contract will not be enforced if either the term itself or its enforcement will be contrary to public policy. That will not come as a surprise to your Lordship. That is Sasfin versus Bierkus, which is cited. B, public policy represents the legal convictions of the community. Since the advent of our constitutional democracy, public policy is informed by our Constitution and the values which underlie it. That's a reference to Afrox versus Stradham and Barkhuizen versus Napier. C, consequently, in terms of a contract, a term in a contract that is inimical to the values enshrined in the Constitution is contrary to public policy and therefore unenforceable. Barkhuizen and Breedenkamp. D, even if a contractual provision is not in itself in conflict with a constitutional value, its enforcement may be. In that event, the first question is whether the right so infringed can in principle be limited and whether it was reasonable and justifiable in the circumstances. My Lord, Mapango makes clear what is trite, which is that terms of a contract which are contrary to public policy cannot be enforced, and that when we look to understand what public policy means, we look to understand what the Constitution is. The clause in the terms of employment which says that you can't talk to the media without permission of the CEO may be permissible when it goes to the strategic direction of the SABC, its commercial imperatives, the rates it pays its employees. Who knows? It might be permissible. But it is plainly not consistent with the Constitution if what it means is that 8 journalists, who consider that there is a policy which is enacted, which is unlawful and which violates their rights and the public rights, are precluded from speaking to the public. If that is what the respondents contend that clause means, then the clause is to that extent unenforceable on the trite principles laid down in Mapango and the other cases. So we say, my Lord, that there is a breach of the Constitution and that this court, of course, has jurisdiction to deal with it in terms of section 157(2)(a) and (b) of the LRA, which gives this court concurrent jurisdiction in relation to breaches of the Bill of Rights. And this court, of course, has the power to order reinstatement by virtue of section 158(1) of the LRA. So we say, my Lord, that these dismissals are therefore unlawful and unconstitutional on both bases and on each of them, and that reinstatement should be ordered in terms of prayer 1A. That then takes us, my Lord, to the second half of the argument. Because assuming that your Lordship is with us and reinstates the employees, the question is, what is to become of the processes that were pending when they were dismissed? And there were 2 such processes. There were the suspensions of the second and third applicants, which were in place, and there were the pending disciplinary proceedings, which were in place when the dismissal occurred. Now, this court, we say, plainly has the power to intervene in respect of both of those. And we commend to your Lordship in that regard the authority of McBride versus Minister of Police, the relatively recent judgment of your Lordship's sister, Ladyship Basson. Your Lordship need not go there, but it is in the bundle of authorities at tab 6, page 187. And at paragraphs 13 to 16, her Ladyship considers in detail the question of whether this court may intervene in incomplete disciplinary inquiries. She says that it may only do so in exceptional circumstances, but where those exceptional circumstances exist, then the court undoubtedly has the power to do so. And she refers in that regard to a series of cases decided by the Labour Appeal Court's decision in Boyson and a Labour Court's decision in Mortimer. And I would just emphasize one aspect, which is she said the LAC in Boyson, this is at paragraph 15, endorsed the decision by the Labour Court in Mortimer, where the court held as follows. And the court gave examples of what an extraordinary circumstance justifying intervention would be. And it said, where a person is in truly extraordinary circumstances approaches the Labour Court on the basis that a disciplinary inquiry was, for instance, about to commence or was conducted in the hands of a biased or unqualified presiding officer, or on another factual basis so serious as to vitiate in law the inquiry, I have no doubt that the Labour Court would in law exercise these powers to stop it. We rely on that last one. We say that for the 2 reasons that I'm about to deal with, there is a proper basis to conclude that the inquiries and the suspensions are in law vitiated. So this court has the power to intervene in those proceedings, and that cannot any longer be doubted. And the only question is whether it should. And there are 2 reasons that it should, my Lord. in our submission. The first is that the suspensions and the disciplinary proceedings are inherently unlawful. Could I deal with the suspensions for a moment? I took your lordship to the suspension, and the suspension of Mr. Kricher, and the same applies to Ms. Venter, said we are suspending you because you didn't comply with a lawful and reasonable instruction. Well, we now know that that instruction was not lawful, and it was not reasonable. So on that basis alone, the suspensions can't continue. But even on the SABC's version, my lord, we quote them again, that the SABC's version is that the suspensions and disciplinaries were due to the 2nd to 5th applicants making comments in the media about their opposition to the protest policy. But my lord, the protest policy has been declared invalid by the CCC, with retrospective effect, in a decision that the SABC accepts is binding. My lord, it is, and that's why we say cynical and extraordinary. It is bizarre that the SABC accepts that the protest policy was invalid from the moment it was enacted, but now seeks to penalize the journalists who had the courage to say so, at a time when, as a matter of law, the protest policy was already invalid. Because that's what it means when we say it's invalid retrospectively. It is as if it didn't exist as a matter of law. That's what the retrospectivity element of the CCC order means. So as a matter of law, there was no policy in force. And yet the journalists who criticized that, who criticized the policy concerned, are now told that they should be disciplined. My lord, it is simply inconceivable that that is lawful. Secondly, and in any event, my lord, there is the breach of the Bill of Rights. And really, I don't need to say more than I've said already, because the argument applies equally. The argument advanced at paragraphs 28 to 32 of the heads in relation to Lotteries Board, the duties of journalists, Kumalo versus Holomisa, all applies equally here. If, as the SABC maintains, these...
I'm sorry, I really hate to interrupt my friend. But my lord, I don't know why he's dealing with suspension. What they've brought now, the orders that they're seeking, do not refer to any suspension. We have in prayer 2, where they say they are entitled to return to work. And when we took it, that it's actually an implementation of prayer 1, the reinstatement.
Are you referring to the amended statement?
They amended it. So my lord, I also restrained myself anyway, even when we was arguing in the I think this argument relating to just before this one, which is also not their case, my lord, about the statement that has been published, that the contract is therefore unconstitutional. That was of the concept.
You're saying that wasn't pleaded? Are you saying that wasn't pleaded as part of...
That was not pleaded, my lord. Their case is not that a certain clauses of the contract of employment must be set aside as either unlawful or unconstitutional. The same, my lord, applies to this suspension. There's no issue about suspension in our view. And again, I'm sorry for interrupting.
No, it's sometimes welcome. Mr. Badland.
Thank you, my lord. My lord, my learned friend is with great respect wrong on both counts. If I could just demonstrate to your lordship. Could I just begin with the contract point? My lord, we don't have to seek an order setting the policy aside, and the contract aside, and we do not do so. The question is whether the respondent can make use of the contract as a defense to what would otherwise be an unlawful and unconstitutional dismissal. And they cannot, on the clear authority of Mapanga, which makes clear that the court will not enforce a contractual term that is contrary to public policy. So we didn't need to plead it, and I was dealing with it because the SABC has put that up as a defense, and it is a defense that is unsustainable, because if the contractual term is unenforceable, then it can't be enforced, self-evidently. In relation to the second point, my learned friend is with great respect wrong again, because if your lordship would turn to the original notice of motion, that's at page 1. This notice of motion was issued on Friday, before there were dismissals, and prayer 2 read, directing that the second and third applicants are entitled to return to work at the SABC and to continue with their respective duties and responsibilities in accordance with their job descriptions. It is plainly a prayer directed at suspension, because that is the reason that the second and third applicants were not at work at that point. And that is the reason that the prayer was only directed at the second and third applicants, because they were the two suspended and the fourth and fifth were not. And when your Lordship reads the founding affidavit, your Lordship will see that there is constant reference to the suspension and why it should be set aside. And so it is, and in fact, just to go to the foot of the end of the affidavit, page 22, paragraph 66, the applicants have no other practical way of addressing the harm caused by the suspensions and disciplinary proceedings at issue. So prayer 2 was about the suspensions, prayer 3 was about the disciplinary proceedings. Then, of course, the dismissals happen. What happens in relation to the dismissals is that the applicants amend their notice of motion, and the amended notice of motion is to be found at page 229. And at page 229, there is inserted a new prayer, 1A, which deals with the termination of contracts. Prayer 2 remains unchanged. So prayer 2 still only deals with the second and third applicants because they were still the only ones who were suspended, and then there's a change to costs. So suspension has been on the table since last Friday evening, a week ago when this was launched, and nothing changed. If my learned friend wants to argue that if the applicants are reinstated, then there will be no suspension, then he must argue that and place that on record. But as a matter of practice and law, my clients are deeply concerned that if your Lordship reinstates them, the attitude of the SABC will be that the second and third applicants are still suspended and the disciplinary inquiries against the second to fifth are pending. So the suspensions are plainly pleaded and an issue in this case. In any event, my Lord, the points I was making about unlawfulness and the breach of the Bill of Rights don't only go to the suspensions, they also go to the pending disciplinary proceedings. And the only point I was making is that the suspensions and the pending disciplinary proceedings cannot be consistent with the Bill of Rights in view of the arguments we've advanced earlier. Could I now turn to the last point on this section of the argument, my Lord, and that is the question of the order to be made in this regard. Now, it's plain in our submission that once this court concludes that the suspensions and disciplinary proceedings are unlawful and unconstitutional, then there is enough in order for this court to grant an interdict. And again, we refer to the judgment in McBride, where the court held that there is an inherent and fundamental prejudice in being subjected to a disciplinary inquiry, which prima facie is unlawful and unconstitutional. And we make the point that the SABC has put up nothing to suggest that there are alternative remedies, nothing to suggest that the balance of convenience favours it, nothing at all on that score. So the only question really is whether the order should be granted in interim terms or in final terms. And at paragraph 44 we explain the position. When this application was launched, my Lord, it was sought only interim relief. And that was for two main reasons. The first was because the SABC had stated that it would be reviewing the CCC decision. So we knew that we couldn't rely on the absolute invalidity of the SABC protest policy, because that is a matter that was going to be debated in at least 3 fora in due course, in the Constitutional Court, in the Helen Suzman Foundation case, and in the SABC's intended review of the CCC. So we couldn't assert to the court that it was absolutely invalid. The second reason is that it was not clear on what basis the SABC would allege that it engaged in the suspension and disciplinary proceedings. We didn't know the reason that they would give. And so it wasn't clear to us that we could establish a clear right. And so we sought interim relief. But both of those have now changed, my Lord. The SABC has now expressly conceded that it will abide by the CCC decision, which found that the protest policy was invalid with retrospective effect. And the SABC has now expressly stated in its answering affidavit before your Lordship that the suspensions and disciplinary proceedings were due to the journalists making comments in the media about opposition to the protest policy. Now, when you run those 2 points together, my Lord, it's no longer a prima facie right. It's a clear right. And so the applicants have established a clear right in relation to both the suspensions and the disciplinary proceedings. And that means that the relief that your Lordship should grant in our submission should be in final form, not interim form.
I'd ask you in that regard. My understanding was originally that the Constitutional Court was going to be asked to decide finally on these points.
Yes. My Lord, there are still proceedings pending in the Constitutional Court, but it is not clear what will become of them at this point, because those proceedings, as your Lordship will have seen from the papers, were premised on the basis that the SABC was going to defend its protest policy to the hilt. That's the very basis on which the Con-Court was approached. That is no longer the case. The SABC has capitulated. Let me be clear. I don't want to be understood to suggest that my clients abandon the Constitutional Court application, nor that there is any need for it. That is a separate matter, and that must be dealt with separately. But what is clear is that, as a matter of law today, the protest policy is invalid, and always has been, from the date of its inception, and the SABC now accepts that. And the Constitutional Court proceedings cannot change that for purposes of today. So, we've referred your Lordship to the judgment in the South Gauteng High Court in Majake at paragraphs 95 to 102. That is also in your Lordship's bundle of authorities. And that case makes clear, after considering all the authorities, that where an applicant launches proceedings for interim relief, but because of developments or what is revealed in the answering affidavit, it becomes clear that they in fact have a clear right rather than a prima facie right, then the court may itself grant final relief. It's a very careful judgment considering all the authorities, and we submit precisely the same applies here. So we've already submitted to your Lordship that prayer 1A should be granted for the dismissals. We now submit to your Lordship that prayers 2 and 3 should be granted also in respect of the suspensions and the disciplinary proceedings. But we submit that your Lordship need not grant prayer 4, which was the one that turned them into interim relief, because my clients are entitled to final relief. If your Lordship is not with me on that point, then your Lordship should grant prayers 2, 3, and 4. But in our submission, there is no need for your Lordship to do so. And it's only if my learned friend can persuade your Lordship that there is no clear right, and it's not clear on what basis he could do so, that your Lordship would not grant final relief. Finally, my Lord, we come to the question of costs. We make the submission, my Lord, and we make it again deliberately, that the conduct of the SABC towards its journalists is not merely patently unlawful and unconstitutional. It is cynical, and it amounts to bullying. And we ask your Lordship to have regard we ask your Lordship to have regard to the following. It's not only the dismissal. It's not only the disciplinaries. It's not only the suspension. It's what came before. It is the meeting that began this all, which is common cause on these papers, at which Mr. Motswaneng and Mr. Matthews read the second and fourth applicants to the Riot Act. That was the meeting which I took your Lordship to, at which all they had done, they hadn't criticized it at all themselves. All they had done was put on independent commentators on the air to express their views. And it was made clear, and this is at page 11, paragraph 30.2, that the SABC wanted complete compliance with the protest policy. It did not want any criticism, even if this was by independent analysts. Mr. Motswaneng stated, if people do not adhere, get rid of them. We cannot have people who question management. This is the last time we have a meeting of this kind. Mr. Matthews added, it's cold outside. If you do not like it, you can go. You've got 2 choices, the door or the window. And what you see from that moment on until today is a pattern of conduct where the SABC is seeking to intimidate its journalists. The very journalists who've been proved right. Because the SABC offers no explanation as to why, when it now concedes its protest policy was invalid, the few journalists who had the courage and integrity to say so should be dismissed. We say that is an extraordinary position, and it amounts to bullying in an attempt to silence its employees. We've referred your Lordship to the Gauteng Gambling Board case, which your Lordship will have seen mentioned in the papers. And there what the court was dealing with was an MEC who had conducted herself in a way that prevented appropriate belief or sought to impede appropriate relief being granted. And the SCA was very critical of her conduct and said it didn't find that she was guilty of contempt of court. I must emphasize that. It didn't find that. It said the best that can be said for her is that although veering towards thwarting the relief sought by the board, cannot conclusively be said to constitute contempt of court. And then it went on to say, even though it didn't constitute contempt of court, that does not excuse their behavior. The MEC, in her responses to the opposition by the board, appeared indignant and played the victim. She adopted this attitude while acting in flagrant disregard of constitutional norms. She attempted to turn turpitude into rectitude. And then the court said what should happen. The special costs order, namely on the attorney-client scale sought by the board and Mafujani, is justified. And it went on. However, it is the taxpayer who ultimately will meet those costs. It is time for courts to seriously consider holding officials who behave in a high-handed manner described above personally liable for the costs concerned. This might have a sobering effect on truant public office bearers. Regrettably, in the present case, it was not prayed for and thus not addressed. In this case, it has been prayed for. It has been asked for. Now, yesterday, my Lord, the Constitutional Court delivered its judgment in the AfriForum case, and it considered that SCA judgment, and it cautioned against reading that judgment as casting the contempt net too wide. And that is why we have no longer sought to suggest that your Lordship need to hold anybody in contempt of court. But what's important is that the Con Court didn't suggest that the SCA's criticism or the Special Costs Award was improper. Exactly the opposite. It lamented the MEC's conduct in that case and said, the MEC not only harassed the board to act in a financially irresponsible and unlawful manner, to inappropriately accommodate a private entity in its offices, to vacate its own expensively and recently acquired official space and move into rented premises, but she also threatened board members and purported to dismiss them for patently unlawful reasons. That's exactly the same here. Mr. Motswaneng threatened my clients from the moment the protest policy was announced and from the moment they had the temerity to do their jobs by putting people on the air who were critical of it. He harassed them, he threatened them, and that harassment and threatening conduct continues today, where in the face of a concession that the policy is unlawful, the people who were right about it all along are still dismissed. We say, my Lord, that two things flow from this. First, that your Lordship should direct now that the SABC is to pay the costs of this application on an attorney-client scale, including the costs of two counsel, because of the patently egregious and unlawful conduct, just as in the gambling board case. But secondly, in order to protect the taxpayer, your Lordship should grant the further orders sought in paragraphs 5A and B of the Notice of Motion. And all that they seek at this stage, my Lord, is that 5A says that the respondent shall within 3 days file an affidavit indicating which of its officials were involved in decisions to terminate the contracts of employment. And they haven't done that. In fact, one of our complaints is that Mr. Tebele's affidavit is deposed to by someone who doesn't explain at all on what basis he has personal knowledge. So this court should direct that 5A be granted, and then within 5 further days, and if your Lordship wants to grant a longer period, that's also fine, of course, the officials referred to should file an affidavit showing cause why they should not be held personally liable for the costs of this application. So there are two separate questions. One is, what are the costs to be awarded? And we say your Lordship should and can decide now that the costs are to be awarded on an attorney-client scale, because my clients are entitled to that, whoever they are to be paid for. The second question is whether those costs are to be paid for by the SABC or the officials, and that is a matter that your Lordship cannot adjudicate today with respect, because these officials have not been named and they haven't been joined. And that is why your Lordship should grant an order in our respectful submission in terms of prayers 5, A and B of the Notice of Motion. Prayer 5C would then stand over for further determination. My Lord, those are our submissions, and we will, of course, deal with anything further that is necessary in reply.
All right.
Thank you, Lord.
Let's just take a 10-minute break for here, Mr. Skosana. Take a 10-minute adjournment. sort of pick. So
Issues, SABC regulations, which actually have been referred to extensively in the papers, but because of the urgency of the matter, we were omitted and not attached.
okay. Thank you.
My Lord, and let me say from the beginning that the clause that is being referred to mainly in those regulations is clause 2D, which my learned friend now says that clause is actually unconstitutional and therefore invalid. But my Lord, I propose to deal with the points as in our answering affidavit, and then thereafter to deal with the issues raised in my learned friend's argument.
Okay, that's fine.
My Lord, the first issue is jurisdiction. My Lord, it is clear, and I think it's that portion is confirmed by my learned colleague that they rely on the unlawfulness of the dismissal. And therefore they say, my Lord, that dismissal is therefore invalid. Those dismissals are invalid. That appears clearly from paragraph 15.2 and 16.10 of their supplementary affidavit. On the other hand, my Lord, they have elected to come to this court, and of course they are relying on the LRA, even if partially so, my Lord. But they cite, for instance, section 157(2), particularly in relation to this jurisdictional issue, my Lord. And we submit, of course, that the only constitutional issue that can be raised in this case would be an issue relating to section 23 of the Constitution, which is the rights to a fair labor practice, which is now codified under the Labor Relations Act. My Lord, the issue of the rights of freedom of expression under section 16 of the Constitution does not arise simply because this is an employer-employee relationship and there is a breach of contract. It's not relevant for purposes of this argument what the issues were between the parties, between the employer and employees. But my Lord, it is an issue between employer and employee. Hence they've come to this
Can
court.
I ask you, I don't know if you had a chance to look at the reference that was made to the Lotteries Board case? Where that seemed to come out as an issue.
Yes, my Lord. As far as I'm aware, my Lord, the Lotteries Board issue, this issue, that's the distinction. This issue of a contract, in other words, a prohibition contained in the contract, does not arise, my Lord. It may have been a constitutional issue in what the employer was trying to restrain the employees from doing. But this case is an additional and very important element. There is an agreement between the parties. And my Lord, these are not unsophisticated people. They are journalists. But my Lord, I'll come to that aspect. At this present stage, dealing with the jurisdictional issue, I wish to refer to the case of and we have placed reliance in our heads of argument on the case of Steenkamp. My Lord, and we have quoted extensively from that case in paragraph 2 of our heads of argument.
Okay.
My Lord, the essence of that case in our respectful submission is that once a dismissal is pronounced, it takes effect. And it may not be avoided by pleading that actually the dismissal was unconstitutional and so on. And therefore seek to set it aside or declare it as void. But then we must deal with the dismissal, and the only way to deal with it would then for this court to say that that dismissal was unfair, either procedurally or substantively. And my Lord, I must also emphasize that the issue also referred to in the lottery sport case is of automatically unfair dismissal, which, if one looks at the applicant's case, to a large extent goes to that actually this dismissal was motivated or based on victimization, which then would fall under the category of automatically unfair dismissal, which would therefore clothe this court with jurisdiction. But my lord, that's not their case. They have deliberately elected to bring it on different bases, which is the unlawfulness of the dismissal. My lord, I've quoted. I don't think I need to reach each and every quotation in the case, from the case of Steenkamp. But my lord, I wish to refer to particularly paragraph 44, which is on page 3 of 144 from Steenkamp's case. My lord, the second part thereof, which reads, accordingly, the dispute falls to be resolved under the dispute resolution provisions of the LRA. The applicants cannot avoid this result by alleging that the dismissal is invalid and of no force and effect. What this passage means, in part, is also that if a litigant's case is based on a breach of an LRA obligation, the dispute resolution mechanism used must be that of the LRA, and the remedy must also be a remedy provided for in the LRA. Accordingly, on this ground, the appeal must be dismissed. My lord, this again emphasizes the very submissions that we have made, that in order for an employee who comes to this court must allege that there was an unfair dismissal. My lord, there is a dismissal now, and I'm speaking after the dismissal was made. I'll deal with the other prayers. I'm dealing with prayer 1A in particular of the amended notice of motion. There has been a dismissal. The issue of whether that dismissal can be or should be set aside should be dealt with in terms of the Labor Relations Act. And particularly, my lord, when one seeks reinstatement, because that remedy is carefully carved in the LRA. It's a remedy which is carefully circumscribed in the LRA, and it says that it can only be granted if there has been a finding of either of unfairness of the dismissal. And my lord, that's I've already said that that's not the applicant's case.
Can I just ask you, Mr. Badlander referred to two cases, one by Judge Basson and I forget the other one, both of which he argues hold that you can seek to have a termination of a contract,
Yes.
which was terminated contrary to the terms of that contract, to have that termination declared invalid.
Yes, my lord.
What do you say about those cases?
Yes, my lord. In fact, I was going to deal with those cases, but my lord, I can say that those cases, of course, deal with the breach of contract by the employee. First of all, my learned friend doesn't refer you to other parts of the policy that he relied on. He referred your lordship to paragraph 1.8, for instance, of the policy, the essence of which, and he says that...
Just hang on 1 second. 1.8.
1.8, my lord. He says that paragraph is irrelevant for the purposes of this case. My lord,
yes.
yes, my lord, what is important about this paragraph, it also defines or describes what summary dismissal mean in terms of that policy. In other words, it would be a dismissal without a formal disciplinary hearing. It says in that paragraph 1.8. And my lord, the policy continues, and particularly there's a second part of the policy which is on page 289 of the papers. Yeah, 289 paragraph 1.2, which refers to misconduct and offences warranting this summary dismissal. Among them, my lord, we have 1.2.3, deliberately causing negative reporting of SABC affairs in the media. My lord, and perhaps while I'm still on that point, my lord, the contracts of the employees, if I may refer them to as the employees, excluding the first applicant, refer to both the policy as well as the regulations as forming part of their contract. That's paragraph 6.37 of their contract of employment. It incorporates the regulations and this policy or the disciplinary code as part of their contract. My lord, may I please, before I continue with my argument regarding the jurisdictional point, say that the regulation that has been referred to, regulation 2D, says that the journalists may not comment in the media regarding their conditions of service. And my last friend says now that that's unconstitutional. But it doesn't end there. It further says that without prior permission from the authorities, yes, my lord, it says there must be permission obtained or consent of the group chief executive. So, my lord, this argument of this clause being unconstitutional cannot stand. There is no allegation, for instance, that they requested permission and it was refused or unreasonably refused. So, my lord, it cannot be, is unconstitutional. Going back to, my lord, the jurisdictional issue. My lord, I also want to bring your lordship's attention to paragraph 5 of our heads, which is, we are quoting the case of De Beer, from which you've also relied extensively. My lord, which that paragraph reads, it is significant that in terms of section 193(1) of the Act, it is only if and when the Labour Court or the arbitrator appointed in terms of the Act finds that a dismissal is unfair, that reinstatement may be ordered. And then it goes further to explain what reinstatement means, which we all know. My lord, we therefore submit that, my lord, the reinstatement that is sought in prayer 1A in the circumstances, the applicants may not argue that these employees are entitled to such reinstatement on the basis of this course of action. My lord, we go on in our heads of argument to refer to the case of Intervalve on paragraph 7 of our heads, which is also a recent case of the Constitutional Court. Still to the same effect, that, my lord, that where matter has concerns dismissal, then it must be referred to conciliation for conciliation. Otherwise, the Labour Court has no jurisdiction. That's on paragraph 115 of that case, and paragraph 7 of our. My Lord, may I also mention, because there has been a reliance on section 157 of the LRA that says that they may raise a constitutional issue before this court. But my Lord, account must also be taken of subsection 5 of that section. Good enough, section 158.2 states that the Labour Court has concurrent jurisdiction with the High Court in respect of fundamental rights which arise from employment and from labor relations. But subsection 5 states, except as provided for in section 158 sub 2, the Labour Court does not have jurisdiction to adjudicate an unresolved dispute if this Act or any employment law requires the dispute to be resolved through arbitration. My Lord, of course, this Act requires that section 158.2 is the one that deals with the Labour Court sitting as an arbitration proceedings. My Lord, then we simply say that even if they are raising a constitutional issue, that does not exempt them from complying with the mechanism provided for in terms of the Labour Relations Act.
What do you say about the argument, as I understood it, that look, we're coming and saying our case is not a case of unfair dismissal in the normal way the LRA provides for that kind of relief. We are here saying that for the reasons we've been dismissed and in the manner we've been dismissed, we actually are entitled to rely on contractual principles. I mean, does the Labour Court not have jurisdiction to deal with something in that context?
My Lord, our submission in that regard is that this is a simple dismissal, like many other dismissals, based on the breach of the terms and conditions of their employment, my Lord, which I've just referred to your Lordship to, in particular, Regulation 2D, my Lord. Of course, the applicants state in the replying affidavit now, they've gone, I think it's paragraph 18 to 21 of the replying affidavit, goes extensively to deny, number one, that look, I didn't do that, I did not go out and speak about this policy to external media. But my Lord, number one, they elected not to respond to the Schedule 8 notice. Schedule 8 notice stated clearly, and it's not correct that it was vague, stated clearly the instances where they commented on the policy to the outside media. And then, my Lord, instead of making representations to the Schedule 8 notices, they elected to come to this court. In other words, they in effect, my Lord, they simply saying, no, look, we're not going to deal with you. I don't know whether that meant we don't recognize you as an employer. We are going to make representations to the court. Worst part, my Lord, is that they don't even make their, knowing very well that this issue, my little friend in his opening statement says, we came to this court, and I think it was in relation to the jurisdictional issue. He said, you came to this court about the Schedule 8 notices. In other words, the employees were dismissed on the basis of the Schedule 8 notice. But my Lord, they don't deal with that. They don't deal with that even in their founding papers. They choose to deal with that in the replying affidavit, clearly, depriving the respondent of that opportunity, especially in an urgent application. And my Lord, perhaps if they had put up this version, and the Lordship will see, as I've said, is paragraph 18 to 21 of the replying affidavit. It's extensive and substantive representation regarding those allegations contained in the Schedule 8 notices. If they had put up those, which we believe it was within their knowledge, they had that information. If they had put up those representations, maybe we would not be here today. The case may have been different, but the attitude was different. The attitude was that, no, we're not answerable to you. We are going to make our representations in court. And my Lord, that point, must say, I'll make submissions at the end, goes also to cost, even, regardless of the result of this case I submit, my Lord. My Lord, to close the issue of the jurisdictional point, I just want to say, we have stated there that if the issue of jurisdiction is crucial, as paragraph 9 of our heads, and is directly linked to the validity and status of the order made by the court. In other words, that's the beer case, the LAC, my Lord, which says, in other words, and it's emphasized in the case referred to in the next paragraph, that actually a court made by the court which lacks jurisdiction is invalid, and maybe it not. It states so, my Lord. It's not me. It's that case. If I can read that paragraph on page 7 of our heads, a court must have jurisdiction for its judgment and or order to be valid. If the court does not have jurisdiction, the judgment or order is a nullity. No pronouncement to that effect is required. It is simply treated as such. That's the Transvaal Provincial Division.
I doubt there'd be any disagreement about that.
Yes, my Lord. I'm simply that in case, my Lord, if you are correct, in other words, that the court has no jurisdiction. And my Lord, I proceed to deal with the issue of the incompetence of the orders, in particular. Prayer 3 and 5. First of all, my Lord, let me emphasize also that in terms of the format in which the notice of motion has been, the amended notice of motion has been done, actually, it is very clear that prayer 1A is a permanent interdict, because my Lord, there is 1A, there's 1A and then 2-3, but prayer 4, which would perhaps have made it an interim interdict, refers to prayer 2 and 3. In other words, it says those are only prayers which would be operative on an interim basis pending the decision of those fora referred to. The decision of those fora referred to. Prayer, in other words, prayer 1A is not affected thereby. So it is clearly a permanent one. And in any event, my Lord, and we've referred to authority, and in particular the De Beer case, that actually it is extremely difficult to fashion the remedy of reinstatement as an interim remedy, because it's permanent. If you reinstate, you reinstate it. It cannot be interim. We have referred, it's in our heads of argument, my Lord, that portion of the LAC decision in De Beer's case. My Lord, I've already, okay, I was dealing with the incompetence of prayers 3 and 5. My Lord, simply prayer 3 we didn't deal with prayer 2 because we're not, quite frankly, my Lord, we're not too sure what that means. My learned friend has perhaps correctly referred to the founding papers and says, no, it read together with the founding affidavit. Perhaps it was referring to the suspension. But now, our view is that we have actually a new course of action. We have now a dismissal, and number one, the suspensions have fallen away. They have no relevance. And the disciplinary proceedings as well, in terms of prayer 3, they have also fallen away, my Lord. In other words, if this court finds that the employees must be reinstated, then, my Lord, they cannot, otherwise, either the employer must reinstitute or institute new disciplinary proceedings. The disciplinary proceedings and the suspension has been overtaken by events. There's now a dismissal. In effect or de facto, there has been a termination of the relationship between the parties.
I just want to understand the point. Does the reinstatement, let's just for argument's sake say you're dealing with the reinstatement back to a date of dismissal. Doesn't that normally imply continuity of the relationship? And though there may have been, before the order of reinstatement, a complete break, the reinstatement, so to speak, heals that complete break and continuity resumes. And as I understand the concern expressed in terms of the relief is the concern of the applicants is if we were reinstated, if we don't also stop the disciplinary proceedings which were pending when we left, they might be reinstituted or continue. Maybe I'm missing something in your...
Yes, I'm also not sure if I understand your Lordship correctly, but if it means that now they cannot discipline their employees after they've been reinstated, then I would submit that this court ought not to do that, because then you would be the management would have now not to be able to exercise their rights against their employees. But my Lord, I'm referring to that insofar as it refers to the disciplinary proceedings that had already been instituted before the dismissal. Our submission is that the dismissal was, of course, based on different and new acts of misconduct. Those acts of misconduct were committed after the disciplinary proceedings had been instituted, and as well as after they had been suspended. Those were suspended.
So what, in your submission, what would happen, let's just for argument's sake, let me follow that, what would happen to those that were initiated in June, for example, those, because as I understand the SABC's argument, you're saying, look, people were not dismissed for what we were charged with, for what they were charged with originally. They were charged with what was in the Schedule 8 notices.
Yes.
Or rather, they were dismissed for that. Yeah. But then what happens to that those previous disciplinary procedures or proceedings which, as I understand SABC to be saying, those were not sort of completed or followed through?
Yes, my submission is that have fallen away, and those disciplinary proceedings. And my Lord, there is no way that they can say now you are reinstated, we are continuing with the disciplinary proceedings. They will have to institute new disciplinary proceedings, and my understanding is that the applicants are not interdicting the institution of future disciplinary proceedings, but they are actually interdicting the continuation of those disciplinary proceedings that had been instituted. And my Lord, my submission is simply that with the dismissal, and I've already referred to that, the dismissal is a fact, which of course can be reversed by the court, but it is a fact. There has been a dismissal, and everything else falls away. In other words, it's a clean slate, if I can put it colloquially. My Lord, that's going to be our argument as far as these 2 points, which is jurisdiction and the issue of the incompetence of the prayers. My Lord, as far as merits, which I've already, through your Lordship's question, already covered most of it. The simple issue is that there is a contract of employment which prohibits certain behavior and conduct by the employees. They have breached those terms of contract, and therefore also committed acts of misconduct, which were contained in the Schedule 8 notices. My Lord, insofar, and at the risk of repeating myself, insofar as they have dealt with in the replying affidavit, we submit that should either be ignored or struck out by this court, because they had the opportunity to deal with that at least in the founding affidavit. They didn't deal with they didn't make representation to the employer for whatever reasons. Secondly, they don't deal with it in the founding affidavit, knowing very well that's the reason for their dismissal. In fact, my learned friend says in opening that these employees, or these were attempts by SABC to silence or to stamp out criticism of the SABC's conduct internally and externally. Now the question would be, externally, and we are interested in the external part. By whom? If it's by these employees, and to some extent I was under the impression that he actually concedes that part. These employees went out because he says it was their constitutional right, went out to criticize their terms of contract in the media, which is prohibited in terms of their contract of employment. And as I've already said, it cannot be argued that term is unconstitutional. It makes room for obtaining permission. My Lord, insofar as the question, and I'm trying to deal now with the issues raised during argument, the public perception Your Lordship raised regarding the retraction of the statement and policy, and of course, my Lord, that has happened. Those facts are correct. What has happened in the regarding the decision of ICASA in the High Court, the Helen Suzman Foundation. My Lord, but this deals not with their refusal to comply with that policy, which has been, one can call it rendered unlawful, but with them going out and criticizing their conditions of employment in the media externally, which is prohibited by their contract of employment. And my Lord, so far as I think the question also, or that submission also answers the question whether the issue of the radio journalist that this statement did not affect them. Of course, my lord, that's a side issue, and my learned friend did state that. But it's about what is contained in the Schedule 8 notices, and which is conduct prohibited by their contract. It's not about the validity or rather the unlawfulness or their refusal to comply with the terms of the policy. No. It's about their criticism. My lord, I'm simply running through my notes just to see if I'm not missing something. I've already covered the point that the lotteries case is distinguishable on the basis that there was no contractual prohibition in that case. And my lord, my learned friend has also mentioned that the order made in the Helen Suzman Foundation case, it's an interim order. It's subject to the review in Part B of the notice of motion in those proceedings. My lord, also one aspect that I need to deal with is the section 77(3) of the BCEA. My lord, I think I've dealt with that, but just for purpose of emphasis is that there is no breach of contract here, because the contract, of course, incorporates the disciplinary code, but the disciplinary code does not simply or does not end at saying you cannot discipline except through formal disciplinary proceedings. It makes room for disciplining without following formal disciplinary proceedings. In other words, a process such as Schedule 8 process.
There was a point raised earlier that the code and Schedule 8 are applicable, and that it's not a you can choose one or the other situation. What do you say about that?
I beg your pardon.
So there was a point made in argument that, as I understand it, the phrasing was that the employer must follow the code and Schedule 8, but it didn't say or Schedule 8, it said both. And you seem to be suggesting there's maybe a choice. So I'm just trying to look.
I'm not sure, my lord, if that was the argument, but nonetheless, my lord, Schedule 8 is another procedure, and I didn't understand my learned friend to be saying a Schedule 8 procedure is unlawful or does not exist. That's not the argument.
No,
there is that procedure, it was followed. What he says is the circumstances under which it was applied would make it rather an unconstitutional procedure or unfair procedure. I'm not sure what he says, unlawful. But my lord, I don't understand the argument to be that Schedule 8 procedure is either an unreasonable procedure or is unlawful or does not exist. My lord, the other aspect which was raised is that of course I've dealt with that. I think just one aspect, my lord.
Sorry, can I, before you carry on?
Yes.
The point I was looking for, if you go, have you got a copy of the heads of argument? It's easier to find there, of the applicant's heads of argument.
Yes, I have, my lord.
Okay, if you look at paragraph 18, they cite the relevant contracts of employment recording the following, and then the emphasized portion says the SABC shall be permitted to take the necessary disciplinary actions allowed and detailed in the relevant legislation and the SABC disciplinary procedures and codes of conduct. In other words, they're saying that clause means that an employer can't elect to say, well, on this occasion we're going to follow Schedule 8, we're not going to cover, or not going to follow the disciplinary code itself.
My Lord, our submission in that regard is that, of course, the labour legislation or the relevant labour legislation includes Schedule 8, number one, and the disciplinary code does not exclude a procedure such as is provided in Schedule 8. It makes provision for that, and I've referred Your Lordship to the summary dismissal, which is on page 289, paragraph 1.2.3, regarding or relating to deliberately causing negative reporting of SABC affairs in the media. Well, that covers that situation, and there is actually a compliance. The process complies with that part of the contract. My Lord, there's also one aspect which relating to that by my little friend who says it doesn't have to, if the contract is unconstitutional or that term of the contract is unlawful and unconstitutional, that does not have to be raised. It is simply unenforceable. My Lord, then there's a myriad of decisions that you must know what your case is before you come to court. Nowhere is it raised in their papers that they are going to ask that certain provisions of the contract be declared unconstitutional and therefore invalid. That's the simple answer to that, my Lord. And my Lord, with regard to the judgment of the case of McBride relating to the power of the court to intervene in incomplete disciplinary inquiries, my Lord, the simple answer to that is that applies where there's no dismissal, before the dismissal, not where there's already a dismissal. So clearly distinguishable. And similarly, my Lord, the submission that there's now a clear right has been shown because SABC has capitulated. That cannot be, my Lord. This is a contractual issue. I've already addressed that aspect. Simply a contractual issue. It's not about the constitutionality and particularly the right of freedom of expression, especially vis-a-vis not the general society, but their employer, the SABC. Well, I believe that I've covered all our submissions.
Just on that last point, because it's clearly one of the important issues in the case. What do you? I just want to be sure I understand the SABC argument, and that is that because they subject to obtaining permission from, I can't remember whether it's the CEO or the COO, they might express public views. That means that they are not absolutely prohibited by the terms of their contract from expressing views critical of the employer outside the employer itself, or outside the workplace, shall we say.
Yes, my Lord. I think it's qualified. It's not absolute prohibition. It's subject to approval, which I believe is common cause that they did not obtain such approval. They did not seek it in the first place. My Lord, the other point which I'm reminded by Leonard, the constructive contempt, my lord, which it relates basically to prayers, to prayer 5. My lord, what I've already stated, I think I've addressed that issue. Number one is that the Schedule 8 notice came before the urgent application. It's not a situation where somebody brings an urgent application and then you issue a Schedule 8 and then you dismiss him. That's not the case here. There's a process that is in place, and in fact, the urgent application was an attempt to circumvent that process.
But just, I mean, if you know that parties are saying, look, hang on, we want the court to decide whether, and you're entitled to disagree and say we're quite entitled to proceed, but where you know that very issue about whether you can continue with disciplinary action is going to be the subject matter of a court hearing, what does it say to the court when you say, well, actually we don't care that it's pending before your court, we're going to go ahead anyway in the meantime, and you can deal with the consequences of that later?
Yes, my lord, that would only apply if the court agrees with my learned friend that the term disciplinary proceedings would cover also the Schedule 8 notices. Then perhaps that could be the case, my lord, but we submit that that's not the case. The term disciplinary proceedings has been referred to extensively in the affidavits, and that very paragraph about the agency in the founding affidavit, I think it's paragraph 8-9, refers to the notices, allegations contained in the notices, and they have referred to in the affidavit to the disciplinary proceedings, in other words, the formal disciplinary proceedings that have been taking place, and that actually that's what was required. They're supposed to have been afforded an opportunity to be heard in the context of a formal disciplinary hearing. So they know exactly when they say disciplinary proceedings what is being referred to, my lord. There is a distinction in this case, and my lord, if
so you're saying, sorry, just to understand, you're saying that the SABC could not have been acting in the face of a pending application if it embarked on fresh proceedings for other reasons?
Yes, my lord. That original notice of motion referred to disciplinary proceedings, and my lord, the other aspect is that they did not seek to set aside particularly the Schedule 8 notices. If that was the case, specifically saying these Schedule 8 notices are unconstitutional, on whatever grounds they raise, they are therefore unlawful or unconstitutional, that would be a different case. But that's not what they sought originally. They referred to disciplinary proceedings. My lord, of course, as far as issues of contempt of court, your lordship knows that the requirements are quite substantive if one has to find that a person or an official has acted in contempt. In fact, my lord, in that case, in terms of the Faki case, the criminal standard applies. It must be proved that it was intentional, and already what we are stating in the affidavit shows that at least there's a doubt that they would have acted intentionally in proceeding to dismiss them, because they don't know you're referring to disciplinary proceedings, you're not touching on this process, we are not making representations, so the process must take its course and be taken to its logical conclusion. And may I say that my learned friend says they responded, they made representation. No, all they did was a bare denial, blanket bare denial, that all the allegations they are denied, that's all. But you see now in the replying affidavit today, they now put up substantive facts to say, no, I was not there, on that day. You couldn't say I reported or I commented at a media interview or whatever on a particular day. I would not have been there for this reason and so on. But I believe that would have been a different case if they had made those representations at the relevant time. It's only in the replying affidavit I've made that point. My Lord, unless Your Lordship requires, I've already addressed the issue of cost. Of course, my Lord, our submission is that this application should be dismissed on one or other of the points that you have raised with costs, including cost of 2 counsel. And my Lord, that in view of particularly the point I've raised about the replying affidavit, my Lord, that either the applicants must still pay their costs or they must be deprived of such costs regardless of the outcome of this application. That's our submission as a court places.
Thanks, Mr. Squasani. Anything briefly in reply, Mr. Governor?
Yes, Lord. Well, just a few brief points. One is that I do need to deal briefly with the question of jurisdiction and the effect of the Steenkamp case. Then I need to say a word on this new clause of the terms and conditions that is now relied on. Thirdly, I need to deal with this new defense in relation to the constitutional argument that there is permission. And then finally, I need to say something on costs. I'll deal with those 4 issues briefly, if I may, in reply.
Okay. Haven't you dealt with Steenkamp already?
Well, can I just give Your Lordship the references, because they make it absolutely clear. If I could lay my hands on my bundle of authorities. If Your Lordship has regard just to the following passages of Steenkamp, it is absolutely crystal clear that what Steenkamp was doing was deciding what the LRA position was. So, at paragraph 103, the judgment says, "My point of departure is that if a litigant's cause of action is contractual in nature, the remedy will have to be found in contract law. If a litigant's cause of action is based on the law of delict, the remedy will be in the law of delict. The applicant's cause of action is a breach of the procedural requirements laid down in section 189A8 of the LRA, and therefore has to be dealt with the remedy." So, and that point is made again and again. It's made at page 100, paragraph 103. It's made at paragraph 118. It's made at paragraph 119. It's made at paragraph 129. And it's made in the very paragraph on which our learned friends rely, paragraph 144. Steenkamp was saying, the LRA, when you rely on the LRA for a contention that the dismissal is unlawful, then you've got a problem, because you've got to go to the CCMA. That has never been our case. Similarly, the new case relied on intervale. Our learned friend says intervale shows that the Labour Court can't deal with it, but the full passage of intervale at paragraph 115 says that the LRA lays down the conditions before a dispute concerning the dismissal of employees for striking may be referred to the Labour Court for adjudication. That's not this case at all. So the jurisdiction point, with great respect, doesn't get out of the starting blocks, and there's been no answer on jurisdictional bases to either Ngubeni or Dayakala. The argument is that our contractual argument is wrong, and I'll deal with that now. So on that point, our learned friend appears to accept Ngubeni and Dayakala, and that must put an end to the jurisdictional point. But what he now says is he says that our contractual argument is ill-founded on the merits, because he says the contract itself permits summary dismissal. And he relies in this regard on the second part of that document, which is called the Code of Conduct, and which appears at page 288 to 289. So, just to orientate Your Lordship, the document starts at page 283, and it starts with part 1, disciplinary code and procedure, and those are all the provisions we've referred Your Lordship to. It's called disciplinary code and procedure. And then in the second part, part 2, which begins at 288, it starts code of conduct. And 1 says the following are examples. Well, 1 qualifies everything. And it says the following are examples of misconduct or offences and do not include all possible forms. 1.1 deals with less serious misconduct, and 1.2 deals with misconduct and offences warranting summary dismissal. That's the heading. Now, there are 2 difficulties for our learned friend. The first is that this clause was never relied on. It wasn't relied on in the answering papers as being a lawful basis. wasn't relied on until our learned friend stood up. It is clearly a last gasp attempt to avoid the contractual problem. But more importantly, that reading of this document makes no sense, because on that reading, 1.2 allows summary dismissal for 8 different kinds of misconduct, including everything from fighting to unlawful possession of SABC property, to intimidation, to all sorts of things. And it renders then clauses 1.8 and 4.5 a dead letter. It is simply not a coherent way of reading the document, and your Lordship will know that when it comes to contracts, we read things in context following the decision in Natal and Dumeni. And it seems to us that although it's poorly worded, what 1.2 is intended to say is that those are offences which will warrant dismissal as a sanction. So the reference to summary dismissal there is not about procedure at all, because it doesn't...
It's just the standard kind of disciplinary
Yes.
code where an employer vainly tries to capture everything an employee might possibly do wrong.
Precise. Your Lordship has the point. It's not about procedure. It's about so that's no answer. And once that is so, then the contractual argument must fail. And we would just commend your Lordship, in answer to our learned friend says our clients should have gone to the CCMA. The answer is to be found in Ngubeni. In Ngubeni at paragraph 19, the learned judge says you can't go to the CCMA to enforce your contractual rights. That's why you have to be able to come directly to this court. That's Ngubeni at paragraph 19, page 9 of the bundle. So the contractual argument must succeed in our submission. In any event, the constitutional argument must succeed. And our learned friend raises 2 points there, and they're both new points. The first is to say that the only constitutional issue that can be raised here is Section 23, and Section 16 doesn't arise because this is an employer-employee issue. That's plainly wrong. Section 16 will not always apply in the context of employee discipline. So, for example, if my clients were being disciplined for taking home with them SABC property, it wouldn't raise a Section 16 issue. Or if they were being, or intimidation, it wouldn't raise. But this one plainly does. And that is made clear by the Lotteries Board case. Then our learned friend says, but the Lotteries Board is different because there was no contractual provision about talking to the media. I haven't had a chance to reread Lotteries Board to check that. But the difficulty for our learned friend is that founders because that contractual provision is unconstitutional. And his only answer is that it is not an absolute bar, it's that it allows permission to be sought from the CEO. That has 2 fatal flaws in it, my lord. The first fatal flaw is as a matter of law, which is that a clause which says, a clause or a statute or a provision which says I may only speak with someone's permission remains a limitation or in violation of freedom of expression. It is called a prior restraint in our law. And our constitutional law is very well developed on the effect of that prior restraint. And there is a convenient summary of some of the cases, ironically, in the very CCC decision which found the SABC in violation of its license, the very one before your Lordship. Could I just ask your Lordship to make a note? At pages 38 to 40 of the bundle, 38 to 40 of the papers, paragraphs 18 to 20, the CCC summarizes some of our law on prior restraints, most notably the print media case, where the Constitutional Court has held that prior restraints, where you can't speak without permission, are inherently a limitation of freedom of expression. But there's a bigger problem, my lord, and the bigger problem is demonstrated by this case. Our learned friend argues, quite seriously, and no doubt on the instructions of his client, that what my clients had to do was they had to go to Jimmy Matthews, who was the CEO, and ask his permission in order to criticize the protest policy. That's the argument. That is the same Jimmy Matthews, it's the door or the window, Jimmy Matthews. My clients had to go to him and say, Mr. Matthews, would you mind if I criticize the SABC for this policy, which you have told me I'm not even allowed to get an independent analyst to speak about on the air? My lord, I again accept it must be a submission made on instructions, but it is cynical in the extreme. The last point on the constitutional issue is the suggestion that there's a failure to plead the issue. That is plainly incorrect. No authority has been cited to your lordship for saying that we cannot raise what is plainly a legal matter and which arises from the answer of the SABC. And again, I say, we are not seeking an order that the contractual provision is unconstitutional. All we say is that all my clients say is that the SABC can't enforce it against them, and that goes to the cases we cited. There's been no answer at all, my lord. Penultimately, there's been no answer at all on the suspension and disciplinary issues. My learned friend does not seek to defend those. All he really says is that we can't get that relief because it's incompetent. But it's plainly not incompetent for precisely the reason that your lordship gives. If an order of reinstatement is given in terms of prayer 1A, my clients will still be facing suspension and disciplinary proceedings. That has to be dealt with by this court, because otherwise we're going to be back in front of another judge a week from your lordship giving his judgment. It is an issue that has been pleaded, it has been canvassed, and we persist in it, and there's no answer, and it's plainly not incompetent. Lastly, my lord, on the question of costs. Our learned friend made what we say is a fatal concession. Your lordship put to him that wasn't it inappropriate of the SABC to proceed to dismiss in the face of this application. His answer was that was only true if disciplinary proceedings referred to in the application included Schedule 8. In other words, he doesn't seem to take issue with the principle that if the reference to disciplinary proceedings includes the Schedule 8 notices, then there was inappropriate conduct by the SABC. But we say then his client's case is in desperate trouble because disciplinary proceedings must include the Schedule 8 notices, and that is for two reasons. The first is a matter of three reasons, in fact. The first is a matter of linguistics. The notice of motion and the founding affidavit refer to disciplinary proceedings, not disciplinary hearings. If we're going to start splitting these hairs, it is plainly that disciplinary proceedings includes all forms of disciplinary proceedings, whether initiated by means of a disciplinary inquiry or Schedule 8. The second reason is a reason I've already given, that the very basis for urgency was the Schedule 8 notices. So it's plain that that was part of the proceedings. And the third reason is that it would be utterly illogical for my clients to come to court to try and interdict the disciplinary hearings against them while leaving in place and allowing to proceed the Schedule 8 notices that could lead to their dismissal. On what possible basis could my clients ever have sought to do that? And there is no way that the SABC can understand that as being the basis of the case. His last point was that my client should be mulcted in costs because the explanation as to what they've done appears in the replying affidavit. My lord, the first time that we got a proper explanation for the dismissal with specificity, well, there's no specificity, but the first time we got any form of specificity as to what my clients were alleged to have done in order to do the dismissals, in order to bring about the dismissals, was in the answering affidavit. In that answering affidavit, my lord, there are the vaguest allegations imaginable, saying the applicants engaged in a protest march. The applicants spoke to the media, of which there is documentary proof, which is never put up. The applicants gave interviews to the media, who are never specified. My lord, we were duty bound to point out to this court, as we did in reply, that those wild and broad allegations had no basis. And so my clients were perfectly entitled to put that up in reply. The truth of the matter, though, as your lordship knows, is that we have been prepared to argue this on the basis of the SABC's version. And so we have therefore not asked your lordship to place considerable reliance on those facts. The case that we've put before your lordship is even on the SABC's own version. The dismissal was unlawful and unconstitutional, and the suspension and disciplinary was unlawful and unconstitutional. So far from it being a case of my clients being mulcted in costs, this is a case where it's the SABC to pay the costs. And we would emphasize to your lordship that my learned friend has advanced no submissions as to why an order in terms of prayers 5A and B would be inappropriate. We therefore ask for those orders, that the officials should be named and that they should be called upon to show cause why they should not personally be liable for the costs. We say to your lordship, in this dispute already, we know that the SABC and the public have borne the costs of the Helen Suzman Foundation in what must have been a massive application on an attorney-client scale. Your lordship will see that from the draft order. There is no reason that the SABC and the public should bear those costs again without at least an investigation as to whether the individuals concerned should be held accountable. My lord, those are our submissions.
All right.
My lord,
Mr.
I'm not re-arguing. I know I'm not entitled.
It's been a long day.
Yes, I'm just pointing out, my lord, so far as he says the argument about the contract and particular regulation 2D is a new argument. My lord, it's raised in paragraph 4.4 of our answering affidavit. They admit it in their reply.
Just give me that paragraph.
4.4, my lord, of the answering affidavit, and in paragraph 14 of their reply, page 336, they say yes, it's not only Regulation 2E, but also 2D. They admit that it was the Schedule 8 notices were on that basis.
Okay, I'll have a look at that. All right, gentlemen, thank you. I will endeavour to give judgment on a Monday morning, but I think the best thing is you must just check with my associate at about 9 o'clock whether it will be ready by 10. Otherwise, I'll give judgment on Tuesday, in which case I'll probably hand it down in Cape Town, or I'll ask a colleague to hand it down here. All right, so provisionally Monday, but subject to confirmation. I don't know what other matters are going to come up this weekend. It seems like there already are other urgents. Okay.
As a
court's adjourned.
All right. Bye bye. Bye bye.